Hit record. And we are in the throes of Unit 8. And specifically, in our conversation in Unit 8, we're talking about the different types of listing agreements, listing contracts, we'll say. Oh my goodness. Julian, you just made me tired. The different types of contracts. And the one we were talking about, and this is just a recap for us, this is where we left. These are full service listing agreements, meaning the firm not only offers the duties of OCAR, but it also offers the services. So I'm going to list it. I'm going to put it in the listing service. We're going to define in just a second. I'm going to put a combo box or an e-box on the property. I may do an open house. We're going to provide you all the services. And there are 3 different types of full service listing agreement. On the open listing agreement, how many firms is the seller dating in an open listing? As many as they want, right? They're playing the field. They've hired 1, they've hired 20. They've hired, it's an open, meaning it's non-exclusive. Now, I know this one is tough because the only one that gets paid is the one that brings the buyer, if the listing firm brings the buyer. Remember, the money sign is when you get paid. So if you list it and you're the one that brings the buyer, that's the only way you'll get paid. Like we said the other day, you guys, these are not allowed in many MLSs today. I think us to better understand why this even exists to begin with. Again, we need to remember a time before the internet. Today, you put it and it goes online and it goes everywhere, right? But once upon a time ago, before the internet, remember we talked about how agency used to be and the buyers had to come to you and you showed them the product you had. And if they didn't like that, then they'd go on to the next real estate firm. It's like shopping for a car. So the benefit with an open listing pre-internet was that several firms had this listing. Again, many MLSs don't allow this today. I have a really good suspicion that once you get through the state exams, you'll never see an open listing again. However, we got to get you through the state exam. So an open listing is a type of a full service listing agreement. Then we have an exclusive agency listing. How many firms, and you can show me how many firms in exclusive agency? Exclusive meaning, that's right, the seller is only dating one firm. However, that firm only gets paid if they bring the buyer or if another firm brings the buyer. If the seller brings the buyer, then they don't have to pay the listing firm. They only pay if them or another buyer. Then we have the one that we like, and the one that we're getting ready to look at in just a few minutes is exclusive right to sell. Again, that word exclusive tells us a whole lot. How many firms? Just one. Seller's only dating one firm. And in an exclusive right to sell, you get paid, you get paid, you get paid, no matter where the buyer comes from. Did you bring the buyer? Did another firm bring the buyer? Did the seller bring the buyer? So this is just a very quick recap. Again, we're talking about the different listing, or I should say, listing contracts, listing agreements. And these are our full service, meanings we offer all the duties and the services. We're going to refresh limited listing in just a second. And this, remember, this slide is in the online learning system for you. So when you're ready to get ready for your exams, you can have this to refer to it. And I think the money sign, it's yours. It's your money. So when do you get paid? And that's what the money sign is telling us. Another type of agreement that we have, and I'm not going to call it a listing agreement because it's not an agency agreement, but it is an agreement, and it's called the protection agreement. And guess what, you guys? This is protecting us. Specifically, if the for sale by owner says that they would pay our commission. So if we're dealing with a FSBO, if we are using the North Carolina Protection Agreement, it is because we are working with a buyer, we are a buyer's agent that is interested in a for sale by owner. And your buyer's going to call you and say, I found this FSBO on 123 Main Street. Can we go see it this afternoon? And you're going to say, you betcha. So then you call the seller directly. The seller doesn't have representation. They don't have an agent. They're choosing to go it alone. So you call the seller and you say, my name is Julie Campbell and I'm working with a buyer. Remember that initial contact. And we want to come out and see your property this date, this time. The for sale by owner says, great, we look forward to seeing you. And you say, if my buyer buys this house, would you be willing to compensate me? Would you be willing to pay me? Is the for sale by owner under any obligation to pay a buyer's agent? Not. Part of the reason some FSBOs will tell you that's part of the reason why they choose to go it alone is to avoid paying that commission. So whether or not they're going to pay us as a buyer's agent or not is entirely up to them. If they say, of course, I will pay you, absolutely. Let me ask you guys something. Shake your head, yes or no. Are you going to take them at their word? Everybody's head should be shaking no right now. You don't know this person. Can you trust this person? Do you trust this person with your commission? So how do we trust our commission? We have a form for that. The form is actually called, and it's in your book, unrepresented seller disclosure and fee arrangement. I think it's in the, see what page are we on, 207? Yeah, there it is, 208. Yeah, 207. So it's the unrepresented seller disclosure and fee agreement. Understand, I'm not trying, it's the in practice on page 207. I'm not trying to create agency. The seller has already said they don't want agency. I'm just using this form to protect my commission. Again, we're only going to use this if they agree to pay us. There's something I always need to do with the FSBO, whether they agree to pay me or not. What is that I need to do with every FSBO? Put money aside. What is it I always need to do with those FSBOs?
Would it be the working with real estate agent form?
That's exactly what it would be, Rochelle. Doesn't that FSBO have the right to know that I represent the buyer? Doesn't that FSBO have the right to know that I don't owe you confidentiality? Doesn't the FSBO have the right to know that anything you say to me, you might as well be talking directly to the buyer? So whether they're going to pay you or not, we always need to do our working with real estate agent disclosure. If we can do it on the phone and let them know before we get there, if not, then as soon as we get there, before we go too far, we need to make sure they understand my role. Guys, always remember that's what the disclosure is about. I'm disclosing my agency status. And in this case, I have a duty to protect the FSBO, which is going to be a customer, and let them know up front. I don't represent you whether they agree to pay me or not. I don't represent the for sale by owner because they didn't hire me. They didn't enter into an agency agreement. Now the what ifs. What if you're talking to the FSBO and the FSBO says, can't we just hire the firm? We want representation. Well, now we enter into an exclusive right to sell listing agreement. We got to talk to both parties about dual agency now, right? So if they do decide they want that representation, then we just know we need to how to proceed. But from experience, for the most part, once they choose to go it alone, especially if you're bringing them a buyer, they're going to remain alone. Just remember in these situations, everything you do is because it's in the best interest of your buyer. They're the ones that hired you. The other type of listing contract, and we mentioned this the other day, is the limited service listing contract or a limited service listing firm. These limit the services, but not the duties. What we mean by that, the firm and all the agents in the firm still owe the seller old car. We're not limiting the duties. We're just limiting the services. And what we see most often, understand our firms can set up their own pricing policies. But for the most part, what we see with these is a la carte pricing. So it's like the limited service listing will hand the seller a menu and say, you tell me what services you want, and next to each of those services will be a dollar amount. So we can tally it up. You want me to put it in the listing service? it'll be X amount. You want me to put a combo box on it, X amount. You want me to do an open house, you want me to be available to show it to buyers, X amount. What I can't limit are my duties under license law and commission rule. Even in a limited service listing contract, which offers do I present to the seller? Which ones? All of them. Am I going to help my seller negotiate? Am I going to help my seller understand this is a good offer? Should we counter? Absolutely. Because my client is still the seller and my duties are to them and getting them what they need. I've actually done 2 of these, both as buyer's agents. And I'll tell you, when I first came across it, I was a little nervous, like, oh Lord, I got to talk to the seller directly. Does this person know what they're doing? I got lucky. Both of my sellers in these cases were investors. And they do this on the regular 10, 12 times a year. They don't need an agent. They just need somebody to get it in the listing service. They need us for our paperwork. They know what they're doing. So they can help offset some of their costs by not paying that full service listing. The one in particular I did, to this day, I have yet to have a conversation with the listing agent. All of my communications, all of them, with the seller. And that's the way that these typically work. So you'll get instructions in the listing service, who to submit your offer to, what to do, that kind of thing. And just make sure you follow those. And guys, remember group boycotting. There's nothing wrong with these types of firms. We cannot call them discount brokers. What does a discount broker imply? That they're not as good, right? That they don't have the services that the rest of us. And that's the group boycotting that we've got to watch out for. They owe OCAR. They owe that full fiduciary. They've just limited the services. Questions on our different types of listing contracts, listing agreements? We got you. All right. Here it is. I have danced all around this. It's so hard for me not to just call it the MLS until I officially introduce it to you guys. What we are talking about with this listing service, what we are talking about with the place that we all go look at our listings, what my commission is, the information that the public can't see. It all comes through what's known as the multiple listing services, or the MLS. This is where it's a membership basis, which means that's part of your dues that you pay. Your BIC will talk to you about your dues because all MLSs are different. So your BIC will talk to you about what those dues are when you join the MLS. And as a member of a particular MLS, for example, the Triad MLS, what we're doing is pulling our listings. Remember when we said last week, a salesman needs a product to sell. And by pulling our listings, by putting our listings in MLS, we've created inventory for ourselves, inventory for each other. I now have all sellers in the Triad MLS. I now have their property to sell. I have a product. I have something on my shelf. If I have a buyer call me and want to buy a home, I have inventory for them. So the MLS allows us to pull our listings together to create inventory. This is also where we offer compensation. The MLS will tell you, if you bring me a ready, willing, and able buyer, this is how much my firm is going to pay you. How much they put in the MLS is completely up to the firm's policy and with an agreement with the seller. We're going to look at our listing agreement in just a second, and it breaks down. How much are you going to pay the listing firm? How much is the listing firm going to share their commission with whomever brings the buyer? Despite what you're being offered in MLS, remember, agency and the priority is about the client. So if you pull something up in MLS and they're not offering the compensation that your firm expects to collect when they work with this buyer, we cannot let that deter us. Remember, we also talk about our commission and the buyer's agency agreement. It says, I will always ask the listing firm or the seller to pay me first. But if they can't or won't, who's the only other party left in that transaction? If the seller's not going to pay me, who's the only party left? The buyer. And that's why we have these agency agreements to ensure our compensation. Guys, there is no standard, there is no set rate. What they're offering is what we get if we bring that ready, willing, and able buyer. I had buyers once, they wanted to see a property. I went in MLS and I looked and they were offering me 0.5%, a 0.5% commission. Now I know we're new. I'm here to tell you right now that doesn't cut it. A 0.5%. So I'm naive sometimes. I know this about myself. And I called the listing agent and said, oh no, I think I found a mistake in your listing. And she said, no, that's what my sellers agreed to pay a buyer's agent. I'm not going to tell you what my firm expects to collect when I work with a buyer, but I am going to tell you 0.5% isn't enough. I sought out my commission from the seller. I found out what they were willing to pay me. And I determined that 0.5% wasn't enough. So before I even showed that property, who was the next phone call I made? To my buyer. I said, you guys need to know the compensation they're offering me is not what you agreed I should make when you buy a house. It's not the compensation you agreed to. If you move forward with this property, you're going to have to come up with a difference. And they said, that's fine. Did you guys hear me? I had that conversation with my buyers before I showed them the property. Yes, I have an agency agreement, but how much time has passed? Does the buyer remember these conversations? Now we're in this situation, in this scenario. Isn't it best to have this conversation with the buyers before they walk in the front door and fall in love? Because once they walk in the front door and say, oh my God, this is my dream house, and I'm going to put the couch there and the TV there, and they start mentally placing furniture, and you're back behind them babbling something about commission, are they listening to you? No. So if there's any dispute, if there's any discrepancy on commission, we need to get it resolved and in writing before I present the offer. But can't we remind them, have the conversation before we ever pull up in the driveway? And it might be a case by case. Corey, your comment makes me very nervous. Let me correct a few things. First off, price fixing says there is no average. There is no set standard across the board. Antitrust price fixing says who sets the commission? Who sets the commission? I need somebody to say it, please.
The firm.
The
The
firm.
firm.
Thank you. There is no average. There is no across the board. It is up to the firm's policy. Like it or not, we can sit and agree or disagree with this all day long. But like it or not, 0.5% commission is what the firm and the seller agreed to pay a buyer's agent. Now it's up to the buyer's agent to determine if that's enough or not. Does that make sense? Never look at a buyer and say, I'm not showing you that property because they're not paying me enough. They're not paying me the average. Remember, it's all the firm. If the buyer refuses to pay, are you stuck? If the buyer's in a written agency agreement, they're stuck. If we're in an oral agreement, I got nothing. Everybody with me? But in a written agreement, we hash out, this is how much I expect to collect when you buy this house. So we talked about the advantages and disadvantages of written over oral buyer agency, and I think we can agree that's a big one. The written protects my commission, but all things about commission have to be hashed out before we can present the offer. Yeah, do you have a question? So what we're going to do now is we're going to look very briefly at our exclusive right to sell listing agreement. This is standard form 101. You don't need to know the numbers, but I do find it helpful in practice in the real world to know the numbers of the forms I use the most often. For example, the exclusive right to sell. Guys, the forms committee, there are hundreds of forms for us to use. So knowing the numbers of the ones you use the most often can sure help you sort through that list and find them. Maybe even thousands. I don't know. There's a ton of forms out there. There's an old joke down at the commission that says there's a form for that. and they're not wrong. So we're only looking at a handful here. Again, more in post licensing. And then once you guys get out practicing, you'll see more as well. To go along with this conversation, if you guys will make a note in your book, starting on page 211 through 216, 211 through, well, actually 217. What you see on 211 through 217 are the major provisions of the listing agreement. I've also gone through the listing agreement and highlighted those things that are mentioned in the syllabus. We are just going to focus on the highlight. I may make a few comments about something that's not highlighted, but to keep us on track with the syllabus, we're just going to look at, break it down into small chunks, and we're just going to look at what is mentioned in the syllabus. Remember, if it's in the syllabus, it's a good candidate for a test question. Also, you have a listing agreement in your book. I don't know offhand where it is. Don't look at any form in your book ever. The listing agreement in your book is already expired. I swear, as soon as they print new books and they update the forms. So never ever look at, everybody hear me? Never ever look at a form in your book. Always come to the online learning system. We have the most current for you guys in the online learning system. So we're under the Unit 8 material, online learning system, 101 exclusive right to sell. And we're going to go through the highlights. These are the big points to focus on the listing agreement. Any questions before we get going on this? Okay, so I got exclusive right to sell listing agreement. You will note it tells me to consult with the guidelines. Some forms come with guidelines for completing. Another one of my super simple philosophies, when in doubt, find out. There's resources, there's tools out there to make sure that we are properly completing these forms on behalf of our firm for our client. So if your BIC's not around, if there's not a seasoned agent laying around, consult the guidelines. And right off, we got that this listing agreement is entered into between the seller and who? The seller and the firm. It's not the individual agent. With the sellers, I need full legal names of everybody that needs to show up on closing day to sign that deed. To convey that deed, and their spouses, whether they're on the deed or not. Always remember, North Carolina is a spousal state. I need full legal names of all those parties. Guys, if you have a seller or probably a seller spouse not willing to sign the listing agreement, I would have a flag go up. If they're not willing to sign the listing agreement, are they going to sign the contract? Are they going to sign the deed to convey it? I need everybody on board today on day one. All of our forms just give us a place for 2 people to sign, 2 sellers, 2 buyers, but we have an additional signatures addendum. So you can add, and I think you can get 8 more on the additional signatures addendum. So now you got 10. If you need more than 10, do another additional signatures addendum. You can do as many additional signatures addendum as you can to make sure all those sellers are on board. Again, full legal names. And spell each party out. Don't Mr. and Mrs. somebody. My name is not Mrs. Ryan Campbell. That was my mother-in-law. My name is Julie A. Campbell. He is Ryan L. Campbell. So make sure you specify that we are 2 separate. We are 2 separate people. So full legal names, and of course the name of the firm. Oh, how about we can make that where we can see it? Is that a little better? Then we got the term of agreement. Remember at the beginning of Unit 8, we talked about the 4 musts. of our written agency agreement. And one of those musts is we have a definite end date. So we need to spell out the term. It begins on the effective date, which is the date that this agreement has been signed by both seller and firm, and it ends on, and then we have a place for the expiration date. This agreement shall terminate at 11:59 p.m. on, and we're going to put in an actual date. How long is the listing agreement for? Well, that may depend on your firm. That may depend on the market. You know, a couple of years ago, we didn't need a listing agreement longer than, a couple of weeks, if that. We get back into a buyer's market, we're going to see properties on the market again for 4 months, 6 months, 7 months, something like that. So what's the average days on market? Again, we're studying the market. We know what's going on around us. So that can help us determine what an appropriate length of time for a listing agreement is. Then we have the property, street address, city, zip, and county. This is a North Carolina form designed for North Carolina agents to be used in North Carolina properties. So they even fill the state in for us. That's one less thing that we have to do. We know the property is located in North Carolina. As a side note, the bottom of page 1 of any of our forms is going to give us some information. First off, once you join the National Association of Realtors, you can rock that capital R, the realtor. If you're not a realtor, if you're not a member, your firm will probably have other forms for you to use, but this is one benefit of joining the National Association of Realtors. Joining the National Association of Realtors gets you into the state level, the North Carolina Association of Realtors. NCAR is who does our forms. NCAR, North Carolina Association of Realtors. By the way, you also have a local level of realtors. So you have like the Winston-Salem Board of Realtors, Greensboro Board of Realtors, High Point, Burlington, Asheville, etc. Most of our forms also have our equal housing opportunity logo. And then the name of the form and when it was last revised. Again, always make sure you're using the current form. And I'm telling you right now, most of what's in your book is already out of date. So this is why we have these here for you guys. So we did the property address, where's it located? And now we need to get some legal description, complete all applicable. So what's your subdivision? What's your tax ID, deed, book and page, that kind of thing. Again, where do you get this? Your firm will help you with that. That's where all these checklists come from. But you have several different sources that you can find this information. Description. Question comes in, does the firm associate with NCAR or is that an individual broker to join? Once you join the local, you get in the local, Winston, High Point, Greensboro, that gets you into state, that gets you into the national. So it's a one membership that gets you into all three. In order for you to be in, your firm has to be in. So you're both going to join. Your firm may or may not tell you you have a choice. Most firms say we're members, so we need you to be as well. And again, each local association has different dues, which changes, the state and the national. And you're not going to be tested on that. So we're not getting into any of that. Your bid can help you with that. New agent orientation, membership, signing up, all that good stuff. It's one of the first things you'll do is join the NAR. So our legal description is complete all applicable. The next section is our fixtures. Now we talked about fixtures. We actually looked at this list back in, I got sirens going by. I don't know if you guys can hear them or not, but I'm not trying to talk over them. So that was like the second round. I don't know what's going on out there, but everybody be safe. So we looked at a fixture list back in Unit 2. Remember we talked about fixtures. The fixture list we looked at was from the offer to purchase and contract. So now here we are looking at a fixture list from the listing agreement. It mimics what's in the offer to purchase and contract. This gives us the opportunity to have a conversation with sellers. If you plan on taking any of this, anything that is considered a fixture, we need to talk now about what's going to happen. Ideally, the seller would take it down. You know, let's say they have some kind of emotional attachment. They'll laugh, but they have some kind of emotional attachment to their mailbox. And they say, this was a wedding gift. Can we take our mailbox with us? I'm not going to tell them no. No. Take a picture of it so you have the memories. No, if they want to take their mailbox, they can take their mailbox. What are they going to do? Ideally, they're going to take it down and replace it with another mailbox before I take pictures, before a buyer ever shows up in that property. We don't always live in a perfect world, though, do we? The seller may look at you and say, I don't want to, you know, jinx my marriage by taking the mailbox down before we move. We're going to leave it up until moving day. Awesome. It now becomes my job as the listing agent to let every buyer that looks at that property know that when they buy, this fixture will not be there. We'll replace it. We'll get another mailbox for it. But if they're not going to take the fixtures down ahead of time, before you list, before you show up for picture day, if they're not going to take them down ahead of time, then listing agents, we have a duty to make sure that everybody that looks at these properties know that this isn't going to convey. Goodness. There's another one. So Kayla says, I had a workout mirror mounted to the wall. My real estate agent didn't ask me about it, and the buyer thought they were getting it. It was a mess. Your story is not uncommon, Kayla. As a matter of fact, added to the listing agreement, July of 23, and maybe it's because of you, we now have exercise equipment, devices that are attached. What happened is the pandemic hit, and everybody went out and bought a tonal mirror or some kind of exercise equipment. It's attached, yes. It's fixed in a way that that tonal mirror is not falling on you when you're working out. Is it considered a fixture? Yes. And what Kayla's saying was common enough. Like we said, I've always heard it. I've always heard this. If we're looking at it in the fixture list, it's the result of some kind of lawsuit, court case, something. So this evidently went far enough with somebody somewhere just this year, or well, July of 23. They added that exercise equipment to prevent buyers and sellers going through what you going through and the mess and getting that worked out. A lot of what we're looking at in the listing agreement is jumping off points of conversations, because we know there's a good chance it's going to come up when a buyer comes along. So addressing fixtures now, having these conversations now is absolutely considered good practice. Thank you for sharing that. On pairing, any fixture that's going to stay, any electronic or smart fixture that's going to stay, the seller needs to unpair it, set it back to its factory default setting before they leave, so the new owner can come in and attach or connect. Our homes are getting awfully smart, aren't they? So we need to make sure that when sellers leave, they're leaving the new owners with those abilities. Anything leased or not owned, the seller can't convey what's not theirs. So if they have, for example, maybe they have a satellite dish that they're renting, they're just making payments on, then they need to get in contact with their satellite dish provider, find out when that can be returned, what that process is, that kind of thing. Again, use this as a jumping off point for conversations. Right after fixture list, we have personal property. What are the things that the seller would consider leaving? Just because the seller is willing to leave the fridge is no guarantee that the buyer's going to want the fridge. So have this conversation with your sellers. Just because the seller is willing to leave the washer and the dryer and the dining room furniture and the living room couch doesn't mean the buyer wants all of that. Remember, it's all negotiable. And we need to have these conversations. You're willing to leave this stuff, that's great. What happens if the buyer doesn't want it? It's personal property, and the seller needs to make arrangements to get it out before the buyer buys, before settlement. We're going to see fixtures and personal property in our offer to purchase and contract as well when we get into unit 10, because those are things that are negotiable between buyer and seller. Next highlight, we got our listing price. There is a commission rule that says I got to have everything filled out before I ask the seller to sign. That's not the commission. The commission rule says specifically, we've got to have a definite listing price before we can ask the seller to sell. Do not put TBD, to be determined. We have to have a definite listing price on the following terms. And what terms would the seller consider? Some sellers don't want to deal with lenders, so they may say cash only. Are they limiting their pool of buyers? Sure, but remember, they are the boss. So we're having these conversations. Not all properties will qualify for an FHA or a VA loan. So what type of financing terms are we going to consider is a specific conversation with the seller, and it depends on the property. We're going to talk about FHA, VA, USDA, conventional, a little bit about loan assumption and seller financing when we get to our financing units 14 and 15. So hang on to those. We'll come back and revisit what all those mean. Right after the listing price, we talk about the firm's compensation. Seller agrees to pay firm a total fee of X amount. Is it a percentage or a flat fee? Remember, typically in a listing agreement, the seller pays the listing firm. The listing firm shares their commission with whomever brings the buyer. So what we're asking the seller for right now is, what is the total amount of commission I'm going to receive? In just a second, I will share with the seller. We will discuss with the seller on what I'm going to share with whomever brings the buyer. But right now, we're just looking for total commission. Our listing agreement tells us when we earn our fee. The fee shall be deemed earned if a ready, willing, and able buyer is procured by the firm, or if the property is sold, optioned, exchanged, etc., during the term of this agreement. So when do I earn my commission? When a ready, willing, and able buyer shows up. My job, remember, we're brokeraging these deals. We are connecting buyer and seller. And I've earned my commission when I've done that. Once I've delivered the seller a ready, willing, and able buyer, I've earned my commission. There's also something called a protection period, not to be confused with the protection agreement that we just talked about with the FSBOs. But basically what the protection period says, if after X amount of days of this listing expired, I didn't sell your property and it expired. After X amount of days or within X amount of days, if a buyer comes and makes an offer, I may still be entitled to a commission. Let's think this through. I've had this property for 6 months on the market for 6 months. The day after it expires, a buyer makes an offer. Is it a pretty good presumption that that buyer learned about that property through my 6 months of marketing and advertising? Didn't I do the job? I just didn't get it happen in time. So I may be able to protect my commission. Again, that within X amount of days is up to the firm's policy, and it's an agreement between the firm and the seller. There are 2 caveats to this. This isn't just any buyer. This paragraph goes on to say that I have to provide the name of a interested buyer to the seller. So it's not just any buyer coming in off the street. It's somebody I've talked to, somebody I know is interested. They just didn't make the offer while we still have it listed. I need to provide the seller with that list of buyers' names. The other caveat to this one, if we expire today and the seller lists with another firm tomorrow, I'm out. Who's the current listing agreement with? The new firm. So if they list with somebody else, I'm out. If I don't provide specific names, I'm out. But if they don't list and I provide specific names, we might still be able to get you paid. Isn't that kind of cool? We just talked about two things that protect our commission. Y'all don't say they don't do nothing for us, because they do. Questions on that protection period? Again, not to confuse it with the protection agreement that we just talked about. So the listing agreement says this is when we've earned our commission. Then it goes on to say, when am I actually going to get paid? There is a difference. And you all need to know that difference, not just for your exams, but for the real world. I earned my commission when I connected that ready, willing, and able buyer to the seller. I don't actually get paid until closing. We're going to talk about closing. We're going to define closing. The other piece of this, if the seller fails to perform their duties, we're getting ready to get into the firm's duties to the seller's duties to the firm. Whether or not, if we don't make it to closing, whether or not we go after the seller for the commission, who's that up to? Who gets to decide if we're going to go after the seller for the commission? Let's say they terminate. They wake up and change their mind. Nah, I don't want to sell my house. Who decides how we proceed?
The firm.
The firm. Because it's not your commission. Remember who this agreement is between. It's between the seller and the firm. So I get that a lot. Can I not sue the seller? You, the individual? No, you cannot, because you don't have an agency agreement with the seller. It's going to be up to the firm. Is everybody with me? It's going to be up to the firm if they go after the seller. And I'm going to say it depends. It depends on the firm. It depends on the situation. There's a lot of what ifs at play in there. For us, what we need to know is there's a period that I earn my commission once we connect that ready, willing, and able buyer with the seller. And then there's when we actually get paid. We get paid when it closes. Guys, this is the dark side of real estate. If it doesn't close, there's a really good chance we're not going to get paid. Cry it out, pick yourself up, dust yourself off, and go on to the next. There are other closings waiting to happen. It's part of doing business. It's part of real estate. Questions or comments on that? Additional compensation, if we're going to make more than what we previously agreed to. Remember at the beginning of this paragraph, we said the firm expects to collect a total of X amount. If we're going to get a bonus or some kind of incentive, and we're going to get paid more than what we need to, more than what we agreed to, I should say, we have a duty to disclose that additional compensation to our client. They have a right to know if I stand to make more than what we agreed to. One thing you guys are going to start seeing as you're looking through these forms, one thing I like a whole lot about our forms, when the need comes up to use another form, they let us know. So if we're disclosing additional compensation, I got a form for that. And specifically, the listing agreement helps direct me in that right direction. North Carolina Association of Realtors form number 770, I think it's called compensation bonuses or something like that. Additional compensation, maybe. But there's a good chance there's a form for that. And if you use the forms to help connect you, you'll make sure you're using the right ones at the appropriate times. So we said how much they're going to pay the listing firm. Now we need to break it down with the seller. How much am I, the listing firm, willing to share with whomever brings the buyer? And we have a couple options here. We can choose to cooperate with subagents, and or we can cooperate with buyer's agents. Remember, we talked about subagency last week. The buyer's unrepresented, either an agent in your office or an agent in a different office are bringing you an unrepresented buyer. If the firm and the seller are willing to work with that subagent, seller subagent, then we have to decide how much of my commission am I going to share with them. And then same thing with the buyer's agent. Somebody brings their buyer client, how much of my commission am I willing to share with them? So again, the seller pays the listing firm. The listing firm shares their commission with whomever brings the buyer. And please do not get it stuck in your mind that this is always a 50-50 split. Sometimes it is, sometimes it isn't. It's completely up to the firm's policy on how they handle commission and an agreement with the seller. And we got to make sure we spell it out here in our listing agreement. Questions on our commission? Remember, our agency agreements are bilateral contracts, and we'll define that word in Unit 9. But a bilateral contract is a two-way street. Both parties have duties and obligations to each other. So in order to make sure we're all performing as we should, our agency agreements must spell out those duties. So first we have the firm's duties to the seller. The firm has duties to the seller to make their best efforts to find a buyer, do whatever it takes to get you that ready, willing, and able buyer. That's what it's all about. Disclose material terms of the offer, making sure that we disclose all offers, all the terms. Disclosure of material facts, other professional services. At some point along the way, the seller may look at you and ask if you have somebody that can do landscaping. Can you make recommendations for somebody that can paint? Do you have a closing attorney you recommend? We might be making suggestions for other professional services. I think this comes up more frequently when we're working with buyers, but it does come up with sellers because there are some services that they need as well. Never look at a client and say, this is who you're going to use and you're going to like it. Remember, they're the one paying for this service. What we need to do is make recommendations. Here's a list of 2 or 3 that I've used in the past. I've had good experiences with. If you're new, you may not have experience with anybody yet. Your firm more than likely comes with a preferred vendor list. So you can use that preferred vendor list to start making those connections, home inspectors, attorneys, all those good people. And you won't be long before you'll start making your own vendor list. I got to tell you, there's nothing like having a closing attorney on speed dial, but you got to utilize that service. You know what I'm saying? Don't expect something for nothing. So we got to recommend, but never look at anybody and say, this is the attorney you're going to use. Give them choices. So let's say I give them a choice of 3 closing attorneys. Do they have to use any of them? No, they can go on and use somebody else. If Cousin Bob is a closing attorney and they want to use Cousin Bob, great. They are the ones paying for it. The firm has a duty to provide the listing to the listing service. That's the MLS that we just looked at. That's our agreement with the MLS. Any listing agreement I get signed, I agree to put it in the MLS. So we need to make sure that the seller knows that that will have to go in the listing service. Another must of our 4 musts of written agency agreements is our non-discrimination clause. Now, it's not normally highlighted pink. I just have it here for you guys. But if it weren't highlighted, it would be bold and all caps. What does it mean if something's all caps? They're yelling at you, aren't they? The agent in the firm shall conduct all brokerage activities in regard to this agreement without respect to the, and here are the protected classes: race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. Further, realtors have an ethical duty to conduct such activities without respect to the sexual orientation or gender identity of any party or prospective party. I got a whole unit dedicated to that paragraph. So when we get into Unit 19, we'll talk about the protected classes. We'll talk about what those mean, and we'll talk about what that means for us. And we'll probably revisit one of our agency agreements, make it full circle so it can come back. Again, all of our written agency agreements must have a non-discrimination clause. Firm has a duty to market the property. The effective date of this agreement is when we enter into the agreement. It's the date that everybody signs it. The effective date and the marketing date are very rarely the same. It's going to be awfully hard to get this signed, get pictures, get measurements, get everything you need to get this into MLS all in one day. So usually our marketing date is a couple days, maybe a week out from the effective date. It depends on your schedule. It depends on your people's schedule. If you're going to have somebody measure or take pictures for you, you need to know their availability. You need to know when they can get out there. You need time to put it in the listing service. You need time to do that research. So the effective date is when we sign it. The marketing date is when it's actually going live, when the world actually sees it. And it can vary. When we market, we're either going to offer public marketing or office exclusive, but not both. If you're going to talk about this listing outside of the four walls of your office, it's public marketing. But you might have a case where you know an investor wants to buy this house. You're getting ready to list it and you know somebody wants to buy it. You may not need to take it public. You may want to keep it in-house. Again, we have to have this conversation with the sellers. But we have a choice to make here, public marketing or office exclusive. So the first one we have, why not both? Because I'm either offering it to the public or I'm not. Again, if I talk about this listing outside of anybody, of the four walls of my office, and if I make it available to one person in the public, I got to make it available to everybody. So if I were to tell you guys right now, I had a listing coming, I've just made it public. Does that make sense? Once it leaves my office. For public marketing, if we're going to do that, we're going to have the seller initial here. And then we're going to select any applicable. There's something called coming soon. It's kind of like a height, building height before it's actually active. All MLSs are different. I know, for example, Triad MLS will let you do coming soon for 7 days. So once you've created that hype and generated that excitement, then you can put it active, get it going. Are we going to put a sign in the yard? Y'all, not everybody wants a for sale sign in their front yard. Not everybody wants their nosy neighbors to know that they're moving. We got to get the seller's permission to put a sign in the front yard. Are we going to do an open house? Are we going to advertise other than the internet? I know the internet is the go-to these days, but there's other forms of advertising. And then are we going to advertise on the internet? Let your seller know. Remember, we're going to talk about safety, and that does include safety for the sellers as well. But we need to let them know that their home is going to be on the World Wide Web. That place that you sleep safely every night is going to be on the internet. So they need to understand the risks. They need to understand, and that's what this paragraph covers. If the seller opts out, if the seller doesn't want advertising internet, I got a form for that. So we have an opt-out option for them. Most sellers are choosing it, but you never know. You may come across one. And then if we're going to go the office exclusive route, again, as soon as it's mentioned outside of the four walls of this office, it becomes public marketing and we need to go back, edit our listing agreement and get this thing in. You cannot, a pocket listing is never allowed. And a pocket listing is where you're telling a select group of people about a listing. You either advertise it to everybody or you don't. It's cut and dry. You can't choose who you want to advertise, who you want to make it available to. Are we going to put lock boxes on the property? And then we got to get the seller to acknowledge a couple things. Now I know when we have a showing, the buyer's agent schedules the showing and they bring the buyers. However, we also need to let the seller know that there might be some unauthorized use, especially with a combo box. Combo boxes are, usually once we get the combo of one, then we know the firm's combos for all. Not as secure as opposed to an electronic box or an e-box. Let's see. So it's either public, yes. So back up here, it says public marketing or office exclusive. One or the other, not both, never both. Could a buyer request an office exclusive home for privacy reasons? No, you're either advertising it to the public or just within your office. For privacy, maybe you, the listing agent, or for protection, maybe you, the listing agent, go. At least sit on the front porch with the showing so they know you're there. Sellers may have concerns, in which case we just need to address them as they come up one at a time. Again, we need to talk to the seller about safety, of course, but we just need to address those concerns as they come up. So seller acknowledges unauthorized use of locks, box, control of visitors during showings or open houses. Showings, again, the buyer should be with an agent. Open houses is kind of a free-for-all. So I can't always have control about who's in the home. The best thing the seller can do is, put up anything that could be considered worthy to come back and take in the middle of the night, right? They need to take a couple steps to protect themselves. Don't leave little things out that can easily slip in a pocket if somebody walks by. Don't put prescription meds in the medicine cabinet in the bathroom. Don't put prescription meds in the kitchen counter over the kitchen sink. Jewelry, that kind of thing. It's worth having these conversations. Any inappropriate use of information placed on the internet. Understand, the only place I put the listing, the only place I have control is the MLS. Once it's in the MLS feeds that listing to thousands, and I'm not kidding when I say that, thousands of other websites. And how they receive that information, it's like a copy of a copy. It's not quite as good as the original. So how they receive that information, how they put it out, I have no control over that. All I can control is what's in the MLS. I can't control how they interpret it. Here's about sellers securing all valuables. Don't leave cash laying around, right? We have to have these conversations. I'm not kidding. Before we go to break, I showed a property once, and my buyer and I walked into the primary bedroom, and there were like 6 or 7 prescription med bottles laying out in the bed. I think what happened, somebody took their pills that morning and chucked it on the bed, took a bill, chucked it on the bed, took a bill and chucked it on the bed. And they just didn't come up before the showing. I have no idea what they were. I stayed as far away as I could. But the what ifs going through our mind right now, right? And I'm sure it was an oversight. I hope it was an oversight. But could we see where that could have gone really bad, really fast, especially if there's some good stuff laying on that bed, right? Easily accessible to anybody. So buyer's agents, be with your buyer. Look out for these kind of things. Listing agents, have these conversations with your seller. I thought in most cases homes were staged for viewing. So it depends on if it's vacant or occupied. If it's occupied, it's probably already staged. But if it's vacant, maybe you can bring in your own furniture and stage it a little bit, or maybe the seller has some furniture laying around. But yeah, if it's occupied, it comes staged. So we just got to work around the seller and their schedule. Remember, we're trying to get them to depersonalize before we list anyway. I sell space. I don't sell stuff. And it's hard for us to see the space through the stuff. So if we can get it to depersonalize, get some stuff down, they got to pack anyway, right? I'm not asking them to do something off. They got to move out. People are looking to buy, not move in with a roommate. So they got to pack anyway. This last thing here, warning. I'll let you guys read this. What this is saying is it's okay to have video. It is not okay to have audio without the other person's consent. So all these technologies, the Ring doorbells and all these cameras and everything we have in the home, when you're going into somebody else's home, I would be prepared to see a video camera. Guys, it's 2024. I need you to conduct your lives as if you're on camera wherever you go, because you know what? There's a really good chance that you are. What we need to make sure, listing agents, is that the sellers understand is they can't have audio without the people being recorded permission. So there's a big red warning for us. Questions so far? Yeah,
Is there
commercial properties are a totally different beast. Yeah.
is there a form for the consent for audio? A lot of cameras have audio.
No, just this red warning box is all we get. So we just need to have that conversation with the seller that they need to turn the audio off. Unless we're going to get everybody's permission. I'm not aware. We'll see. LaJoy says in North Carolina you can record without their consent. I'm not aware of that, LaJoy. What I know is what my form tells us. So in this case, and until it might be, you know, technology moves faster than the law, right? So it might be the forms haven't caught up yet. But what I know right here, right now, is that the seller can't have audio, just video. With that being said, as a buyer's agent, I caution my buyers. They shouldn't have audio. I don't care if my buyer walks in the front door and says, oh God, look at that carpet, it's so tacky. Whatever, that's their opinion, they're entitled to that. What I don't want is my buyer walking in the front door going, oh, this is it. This is the one. This is my dream home. I will do anything for this house. The seller sitting on their phone listening to this, and what did they just hear? Cha-ching, 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 cha-ching. So even though we say the seller shouldn't have audio, as a buyer's agent, I still give my guys the heads up. Sometimes I do a really good job and I can't get them to say a peep in the house. But okay, here's everybody telling us what North Carolina says. What we need to know, what's going to get you through this test, is on the listing agreement. If you want to argue this, take it to the North Carolina Real Estate Commission, take it to the North Carolina Association of Realtors. Everybody with me? Okay, let's take a break. We come back, we'll finish up this listing agreement. back. Cameras are on. So I am going to take attendance and let's get back into this listing agreement. Okay, so all that was under the firm's duties. Again, it's a two-way street. Firm has duties to the seller. We will see the seller's duties to the firm in just a second. The earnest money. We're going to talk about earnest money when we get into unit 10 in our contracts. But for right now, we're just letting the seller know whether or not we do or do not maintain a trust account if we hold the earnest money. It talks about what happens if a dispute arises over the earnest money. So again, just hang on to that. I don't want to spend too much time on this now because we will spend time on it when we look at our offer to purchase and contract. The seller also needs to make some representations. This is information the seller is telling the firm that the firm should be able to rely on. So remember, the seller doesn't have to disclose, but they can't lie. So we're asking the seller some information, like what's your length of ownership? You've owned the property for at least 1 year. You've loaned it for less than a one year. Typically speaking, who is the seller that owns it for less than a year? Typically. I see mouths move. Yeah.
Investor.
Investors, flippers, that kind of thing. Yes, house flippers, yes. Some lenders care about that. Some lenders don't. Some loan types, some products that may or may not matter. So we're just asking the seller to represent. They also have the opportunity to represent if they do not yet own the property. We're seeing more and more of this. You guys may have heard about wholesalers. They're starting to make their entry into this industry. The problem is there's no one definition for wholesalers. But what we know is they're trying to buy so they can turn around and sell it for a profit. Again, fairly new to the industry. Not all some wholesales are fine if they're doing it right, but the commission is starting to pay attention. I will say that the commission's starting to pay attention because not all wholesalers are handling it right. There's somebody that does not yet own the property. That could be what we're dealing with there. If the seller is or is not under bankruptcy, if they are not contemplating bankruptcy. Roads, access to the property. Is there a public or a private road? Is there a manufactured home on the property? If so, what is the model, year, VIN number, etc.? Is the property subject to owners association? If so, who is that contact? The buyer is going to need to know this information. So who's the contact? How do we get in touch with that HOA? Let's see, flood hazard, is or is not in a flood hazard, does or does not have flood insurance. Synthetic stucco, we talked about that. If it's EIFS, is there a termite bond on the property? And then this is where it gets deep. We got to ask the seller their current liens. And you note here, I got a place for 3 of them. But what I'm asking the seller for are approximate balances. I'm not asking how much to go down to the penny. I'm trying to get a rough idea. And if these approximate balances, the first one and then the second one and the third one, and maybe we have additional pieces of paper for the 4th one or the 5th one, all those approximate balances start adding up. And at some point you're going to think, gee, can they afford to sell this house? Guys, some sellers are underwater. What it means to be underwater is they owe more than the property is worth. And if your little red flags goes up because their approximate balance amount is going up, we need to make sure that they are they starting foreclosure or short sale procedures? We'll talk about those in the lending units. But if not, are they prepared to bring money to closing? Not all sellers get money from closing. Again, this is a hard conversation to have. These guys are strangers. I just met them. And here I am. What's your debt? What do you owe on the house? But guys, you got a choice. We can either have these hard conversations up front, or you find out the day before closing, the seller doesn't have the funds and they can't afford to sell. Which would you rather do? Hard conversation up front, right? Don't go through the whole process for them to say, I don't have that kind of money. I can't afford to sell my house. So we got to have this conversation up front. And again, use the listing agreement as kind of a jumping off point for conversations. And those approximate balances start adding up, then we need to be prepared to address that with the seller to make sure they can afford to sell. Their leases on the property is or is not subject to a lease. An FHA appraisal has or has not been performed within 4 months. Any special assessments, we talked about special assessments, maybe by the government or the HOA, both are for the improvement of the property. So if there are any special assessments, the seller's asked to list those there. Fuel tanks on the property. I got a place for 2 tanks you can see here. But use of the tank currently in use, not currently in use. The tank is owned or leased. It's above ground or below ground. What kind of fuel is in it, refueling schedule, and then the name and contact information of the fuel vendor. And I got a place we can go through that little exercise again with a second tank. And then we're going to let the seller know that the tank is included in the sale. Any tank described above that is owned by the seller shall be included as part of the sale. The fuel, the seller can use the fuel in the tank through settlement, but they cannot remove it or try to resell any unused fuel. The buyer buys acquiring whatever fuel is left in the tank. So just a couple notes there. The sellers are advised to contact their fuel provider. We're going to have to do a transfer anyway, so from the old owner to the new owner. If there's an off-site or separate septic lot, boat slip, garage, parking space, storage unit, etc., we're asking the seller to disclose that. Government compliance, any permitting issues, stormwater, that kind of thing. We're going to see this again in our listing or our offer to purchase and contract. So again, seller representations, we're just, again, let the forms help you know what to say. Let the forms help you put words in your mouth. See, I just created a checklist for you. These are various things that we can go through and ask the seller as we're completing the listing agreement to help prepare to get it ready so we can get all the information out. So if the firm has duties to the seller, like we said, this is a two-way street. So the seller also has duties to the firm. Seller agrees to cooperate with the firm in the marketing and sale of the property. They're going to provide the firm in a timely manner. There are some seller disclosures. There's something called a Residential Property and Owners Association disclosure, which we are talking about next. There's something called the Mineral and Oil and Gas Rights disclosure, which we will also talk about. And then there's a lead-based paint or lead-based paint hazard disclosure on anything built prior to. What's the magic year for lead-based paint?
1978.
1978. So again, you guys, once you get through these tests, that year is right year for you. You don't have to memorize it, but we got to know it to get through the test. As far as lead goes, that magic year is anything built prior to 1978. We'll look at the disclosures in just a bit as well. Seller also has duties to make the property available for showing, and this does include working in existing utilities at reasonable times and upon reasonable notice, especially if the home is occupied. The seller may want some lead time, give them time to make the beds and get the cereal bowls out of the sink, before the buyers come. So they may want some lead time. And we're also going to work as best as we can around the seller schedule. Y'all understand, to you, it's a job. To them, this is their home. Has anybody ever sold a house before, been the seller, sold a house? It's a full-time job, isn't it? Like I said, you just can't get up in the morning and not feel like making your bed. You can't get up and not feel like doing something with your breakfast dishes, right? You gotta keep it show ready at all times. So just making it available at reasonable times. What we're dealing with right now is a lot of sellers working from home. So how can we work around your work schedule and still get these buyers in? But it's back to that one-on-one conversation, what works for you. Providing the firm as soon as possible. Restrictive covenants, if we're in an HOA, bylaws, owners association statement, title insurance, surveys, etc. They're going to provide us with anything that we need to help sell this listing. They have a duty, there's our general warranty deed, to convey fee simple marketable title. The seller represents that they have the right to convey. Remember, that's the seller's biggest obligation, to be able to sell. And if anything prohibits them from selling, they're in breach. They've broke their contract. They've broken their agreement. So having these conversations up front as part of the listing is saving you time later on. Let's see. We're going to help the seller figure out how much they're going to get. Do you think that's a common question from sellers? When you sell my house, how much am I going to get? What you going to put in my pocket? Well, we're going to help them calculate that. We're going to help them figure out what their net is. That's part of the math we're getting into in the end of Unit 8. That's also where we're heading in Unit 21, helping them with those figures. Let's see what else we got here. Photographs and other materials. When I come into your house and take pictures, even though they're pictures of your home, those pictures belong to me. They're my work. If you stop listing with me and start listing with another broker tomorrow, that new broker needs to take their own pictures. They can't take mine. They're my copyright. So this is just saying that these pictures are my property, those materials. Make a note, please. Page 10 of the listing agreement talks about dual agency. I think you guys should all look at this. I know we're looking at everything highlighted, but I think specifically you should look at page 10. Talks about dual agency. It's another way for you guys to help you understand dual agency. So we talk to the seller about what it means to be in dual agency, how we can disclose and cannot disclose information, what's the firm's role as a dual agent, what's the seller's role. And then we give them a description on designated dual agency. So again, I think you guys should look this over. And then we got to get authorization to do or not to do dual agency. So you can see here again, I got another or. We have choices. We either do dual agency or we do not. And we keep giving them exclusive representation. Understand you can't do both. They either get exclusive representation or they agree to be duly represented. That's what dual agency means, duly represented. So we got to get initials to one or the other. Either we agree to do dual agency. If so, we're going to initial there. Seller does or does not authorize the same individual agent to practice dual agency. If we are going to do dual agency, can we take it a step further and offer designated dual agency? Please never assume that designated is an option. We've got to be told. So if your firm offers designated and the parties agree, we can get them to initial there. Question comes in, can this be changed down the road if they change their mind? Yes. Basic contract law says if you're going to change anything in writing, the only way to change it is in writing. So if they say no and then they later change their mind, we need to come back and amend our listing agreement. Or exclusive representation at all times, and they do not authorize dual agency. So again, I think pages 10 and 11 of the listing agreement, I think you guys should look that over because it kind of spells it out as it's explained to the seller. Any good contract has what happens if we breach, if we have to terminate, if we don't make it to closing. So this spells out, prefer to go to mediation over a court trial, if at all possible, attorney's fees. Breach, if either party does or doesn't do what they promised to do. So remember, the firm has duties to the seller and the seller has duties to the firm. And if either party does or doesn't do what they promised to do, then they're in breach. And that's what this is addressing, or if they just terminate. Wire fraud, I got a wire fraud warning in the listing agreement to the sellers. We'll see a wire fraud warning in the buyer's agency agreement to the buyers. We're gonna see a wire fraud warning again in the offer to purchase and contract. Wire fraud has gotten really big, really fast in real estate. I mean, think about the millions and billions of dollars that change hands as part of real estate, just in the economy every year. And now we've learned that we can do this all electronically, wire transfer. Oh, the hackers love that. So we need to have conversations with our buyers and sellers, in this case with the sellers, if they want to receive their proceeds via a wire transfer. That's what this, after closing, that's what this is addressing. And again, it's all caps and it's bold, so it's shouting at you. But bottom line, what this is saying is that we need to look the sellers in the eyeball and tell them, I will never email you wire transfer instructions. If you want your proceeds to be electronically transferred, we need the sellers to go old school, pick up the phone and call the closing attorney. And they need to call a number that either they obtained or you gave them. Don't have them call off of an email, because now they're calling the hackers to get that information. You guys with me? So they need to go to Google and look the number up, or you need to give them the number, but they need to go old school and pick up the phone and call the attorney and provide their wire information. And by telling them that I will never email them, should they get an email, they need to let me know, because I've been hacked. My Gmail is about as secure as my closet door. Really easy for hackers to get in. So help your sellers and buyers, help protect them. Don't email. And if they do get an email from you, please let me know, because I've been hacked. So then we got a place, as we said, I got a place for 2 sellers to sign if you have their information. If you have more than 2, then we have an additional signatures addendum. You can add as many sellers that have to sign that deed and their spouses. I got to get everybody on board on day 1. If your seller is an entity, a business, we have a place for that. And then there is one person, the name here, that is authorized to sign on behalf of that entity. So that's probably who you're talking to. And then we have down here at the bottom, the firm's information, firm's license number with your office address, signed by you, the individual agent. As a general agent with your firm, you have the ability to sign on behalf of your firm. The firm is a business. They don't have a body to sign, so they let you do it. Another must, because we're the one signing it, it needs to include your individual license number. Once you guys get your license, you'll get a 6-digit number. Please just memorize it, because you need it everywhere you go. And that's our 13-page exclusive right to sell listing agreement. But like we said, guys, this is a great conversation starter. This is a great, I mean, this covers many things, much information that we need to know to help get it listed. And we're just going through with the seller our firm's terms as far as commission and getting this agreement signed. Questions on our exclusive right to sell listing agreement?
Julie,
Yeah.
any changes that we do will be made to the same form? Right.
Yeah,
Okay.
so we have, it's called, I got a form for that. It's called a agency agreement renewal and or amendment. So if we're going to change the expiration date, if we're going to extend the expiration date, if we're going to change the price, you know, you could use the form. But then there's nothing against contract law that says you can't strike out right on this. It may just come down to your firm's policy. Some firms may say, well, you got a form available, why not use it? Other firms say, I don't care, just get everybody's acknowledgement of the change. If we're making a change right here on the form, then we're striking through right in the new and everybody's initial and dating at that change. But as we can see, I don't have a lot of space in the margins. So it might be that the form is a little bit easier to, and they got a form for that. So thank you, Forms Committee. There's many times I say thank you, Forms Committee. Few times I don't, but most of the time I say thank you, Forms. Other questions? Again, I'm in the Unit 8 material in the online learning system. It's right here with the highlights. The highlights are what's in the syllabus. I welcome you guys to look through this whole thing. You're going to have to eventually, but to focus on your exams, focus on the highlights. When you come to post-licensing, we're going through this thing in a lot more depth. If you get your first listing before you go to post-licensing, I need you to read this before your listing appointment, please. All right.
Julie, just a question. So when we
Please.
get with this class, how far out is the post-licensing class?
You can start it as soon as you get your license. Anybody remember how long you have to complete post-licensing? That's the question we need to know. How long do
18
you,
months.
18 months.
18 months? Okay.
you could get licensed today and sign up for post-licensing tomorrow, but you have up to 18 months to finish it. It's a year and a half. I know you think that sounds like a long time until you get busy in your new career. So y'all, please don't let that time get away from you. I had a gentleman in my last post-licensing class. He had 4 months to knock out all 3. I said, what are you doing? What are you? He's like, well, I got busy. And so he's
In
got,
your experience, is it best to go ahead and just jump right back into it?
I think so, Tank, because it's fresh. I mean, this guy really struggled because it's been a year since he saw agency. You know what I'm saying? So it's kind of like, we know what happens if we don't use it. If you put the book down and walk away, we know exactly where it goes, right? Like out there in the atmosphere somewhere, you know? So I do think it's best, but I also understand you guys all have different agendas. So that's why they give you 18 months. That's why they give you time. But some of you are ready to activate, affiliate with a firm, and you want to work with buyers and sellers while you're getting through post. Others of you may choose to remain inactive until you get through post and then affiliate. There's no wrong way to do that, as long as you do it within 18 months and whatever's best for you. And again, I stress, please don't let that time get away from you. Don't be like the guy in my last class that had 4 months to knock out 90 hours. That make your head spin a little bit? It should. So please don't be like him. Let him guide you. Okay, listing agreement. Anything on our listing agreement? Gotcha. Why don't you guys set your chats to private? Private chat, just to me. And in a private chat, tell me A, B, C, or D. Everybody in? all of the following are true of a listing agreement under North Carolina Real Estate Commission rule, except. So we're looking for the one that doesn't belong. I'm gonna try really hard. I'm gonna make all the promises I can, but y'all, that word guarantee, that's a big word, isn't it? That's a big, strong word. Please be careful using that word. Do not look at a seller and say, I guarantee I'll sell your house. You might be buying it. So just be prepared. That word. I actually had a seller look at me once and ask me, look me in the eyeball and say, can you guarantee you'll sell my house? Sometimes it's worth it to pause and count to 8 before you respond. And when I did respond, I said, I will do everything in my power, but I cannot guarantee that a buyer. He took it, probably not the answer he wanted, but be careful where you say, oh yeah, sure. Because now the expectation is that I'm going to try everything I can, but I cannot guarantee. Unless you have a crystal ball or some way to predict into the future. If you do, reach out to me after class. I'd like to get with you. That would be awesome. All right, couple other things about sellers. One thing, again, we've danced all around, but we haven't head on directed yet. It's talking about residential square footage, specifically residential square footage guidelines. Understanding, note that word residential. How we measure properties for a residential is different than commercial. Commercial is a totally different beast. So this is specific for homes, residential. Fun fact, the total heated square footage is not a material fact in the state of North Carolina. The Real Estate Commission doesn't require us to disclose the total heated square footage. It's your local MLS that will determine if it's required or not the Real Estate Commission. And guys, they can't test you on the specifics of the local MLSs. So for our purposes, square footage is not a material fact. However, if you do disclose it, it must be accurate. I can only speak for Triad and Charlotte MLSs. They require the total heated square footage. It's not the Real Estate Commission. There's a couple different things that we're talking about here. There's the total heated square footage. How much is under this roof can we count as total heated square footage? The second piece of it might be reporting the dimensions of each room. So the kitchen is 20 by 16. The living room is 11.7 by 18.3 or something like that. So there's a couple different things. Focusing specifically on the total heated square footage, not each room, just the total heated square footage. In order for me to count it as total heated square footage, I must have 3 things. It's got to be adequately heated by a permanently installed heating system. You cannot put a space heater in a room and say it has heat. It's got to be a permanently installed heating system. And please note that word says heat. AC is not required. AC is a luxury. It's got to be finished to generally accepted levels of construction, which means I need walls, floors, and ceilings. We can't be looking at studs and rafters and plywood. It's got to be finished. We have to have a ceiling height of at least 7 feet. You start marketing and getting into older homes, you may be dealing with bedrooms on the 2nd floor that don't have that ceiling height of 7 feet. If you're dealing with a 100-year home, I mean, 100 years ago, we were all a lot shorter, weren't we? So we weren't building homes as tall ceilings as what we are today. I'm not saying you can't market and advertise it. What I'm saying is whether or not you can include it in your total heated square footage. And then the third piece, yeah.
What if it's like an A-frame and one point is 7 foot tall?
So
I know
they
that-
allow 5 feet under slopes. So if
Okay.
it's under slopes, yep, good question. So if it's under slopes, then it's 5 feet from where the slope starts. So there's your bonus rooms in your basement, maybe, or like you said, an A-frame home. And then the third piece has got to be directly accessible from other heated living space. In other words, you need to be able to walk from room to room to room through heated, finished space. If to get to a room, you have to walk through an unfinished and or an unheated space, you can't count that in your total heated square footage. Let's talk, for example, about a finished room over the garage or a frog. Finished room over garage. If to get to the stairs, to get to the frog, you have to walk through the unfinished garage, then I can't count the frog in my total heated square footage. I can market it and I can advertise it. I can say an additional 450 finished feet upstairs, but I can't count it because you had to walk through the unfinished, unheated garage. Now, if the stairs are behind it and run from like the kitchen through the laundry room, and then you get up the stairs and you never go through the garage, now we can count it. So directly accessible, maybe there's a breezeway. If the breezeway is not finished or heated, then we can't count it. Take a good rule of thumb. If you walk from room to room and you get cold in between, you can't count it. So in order to count it as total heated square footage, we must have all three of these criteria. Now, this is about the time of the class I start getting a lot of questions. If this space would count, you know somebody that has space that looks like this, would that count? I haven't seen it, so I don't know. But what I encourage you to do is look at that space and see if you have all three of these. Is it adequately heated? Is it finished? And is it directly accessible? If so, then yes, you can count it. If not, then you can't. Not so much that matters to us as it does to appraisers, but whether or not space is above grade or below grade matters more to appraisers. Below grade space doesn't quite have the value as above grade. The difference, below grade has part earth touching one side of it, one piece of it. If one side is touching earth, it's considered below grade. Appraisers aren't going to put as much value on below grade. Again, we're going to get into appraisers in Unit 17. You and I are not appraisers. We don't get to determine things like value. So we're not determining the value of below grade space, but it is worth considering, especially when we're helping the seller price it. We do need to take this into consideration. We're going to look at Appendix C in just 1 second, so bear with me. So we have my picture here. The above grade, this is the main living area. And then down here, you have, room down here as well. But, one of these sides touches earth. Everything doesn't, but because one side does, this whole space down here would be considered below grade. As a refresher, unpermitted space can be used. We can include it in our total living here, total heated living area, but we have to disclose that that space was not permitted. Since we're going through the sellers, if we come across unpermitted space, I can count it as long as it is directly accessible, finished, and heated. I can count it. I just have to disclose that that space is not permitted. So let's just, some of you, I know we said, or we've mentioned, I can pretty much take all the agents I know practicing today and put them in two different buckets. Half of them I know measure their own listings. They bought the tools, they have the time, they have the energy, they have the know-how, and they go out and measure their own listings. The other half I know hire somebody to go out and measure for them. That's a decision you guys need to make one day, not today. You don't have to decide anything today. But we do need to have an understanding, because ultimately, no matter who's measuring it, you are responsible for it. So if you're hiring somebody, the good rule of thumb is we need to hire somebody with more experience than us. So we're hiring appraisers or maybe a seasoned agent that knows what they're doing. Do not hire the 16-year-old down the street. because you are ultimately responsible for it, no matter who measures it. So we need an understanding, whether you're going to measure or not, we need an understanding of how this is going to work. And if we were just to look at a very, I'm not an artist, y'all, but if we have a house and then maybe up here we have the garage, is that enough that we know what I'm doing here? If we were to measure, and maybe we even have, let's put a porch. Let's put a porch right there. So there's our porch. There we go. There's our house. Porch. If we were to measure this house, we always start outside. And we measure from corner to corner to corner. So we would go, you know, from here to here, here to here. Maybe we can get through the porch. Maybe we have to go around it. Here to here, to here, to here, to here, measuring outside, corner to corner. And this gets us everything, and then add it all up. This gets us everything under the roof. Then to get the total heated living area, we go inside and deduct what doesn't count. We go inside and deduct the things that are not heated, finished, or directly accessible. So to get the big picture, total heated living area, you start outside and then you go in and deduct the space that doesn't count. If it doesn't have those three musts, it doesn't count. You may get a listing where the second floor, the second story, is bigger than the first story. So then see, here's our house. The second story is bigger than the first story. I don't want anybody ever up on a ladder trying to measure the second story, but promise me, we're always going to be safe, right? If you're dealing with a second story that's not the same as the first story, we can measure the first story outside, but now to get the dimensions for the second story, now we got to go inside. We measure the inside walls. Let me rephrase that. We measure the inside exterior walls. And what I mean by an exterior wall is the other side is the outside. So you measure the inside exterior walls, and then you have to add 6 inches to account for the depth, the width of the sheetrock, the framing, the insulation, that kind of thing. So for whatever reason, if you can't measure outside, then you go inside, measure exterior walls, and add 6 inches. The exception to that rule is if you're measuring condos. Condos, you always measure inside and do not add 6 inches. Remember, condo owners own from paint to paint, sheetrock to sheetrock. So we're not going to take into account for that exterior wall. It's a process. It takes time. When you guys get started, if you're considering, I would recommend shadowing somebody. There's a top producer in your office that's getting a listing soon. That's why they're a top producer. So make friends with the top producers. They're great friends to have. And see if you can just go shadow, which means you're just watching. Let them do the work. But you're just watching them do it. When you get your first listing, if you want to measure it, I encourage you to have somebody shadowing you to make sure that you do it right. But as you do more and more of these, you get better and better. I will never forget the first house I measured. I took a general contractor with me. He didn't say much. He let me figure it out. I mean, he was a big help, but not in a helpful way. You know what I'm saying? Y'all, we were there all day. He has to be the most patient man I've ever met, because I even lost my patience at some point. We were there all day long. And the second one I measured didn't take as long. The third one didn't take as long. Once you do a few of these, they get easier and easier. So if there are multiple rooms along one side of the house, you add 6 inch for each wall. No, just the exterior wall. So there's exterior and interior walls. And the difference is what's on the other side. If the other side is the outside, that's your exterior wall. If the other side is inside, that's an interior wall. So we're just adding 6 inches to exterior walls. We did pictures that day too. We did pictures and measure. I didn't think we were ever going to go. I thought, this is it. I'm just going to live here because I'm never going to get out of here. It was a long day. The first one was rough. The second one was a little easier. The third one was a little easier, and on it goes. Again, you guys have that decision to make. You can, I get asked all the time, can I ask the seller to pay to have their house measured? I mean, you can. Remember that competitive listing appointment? One of you is asking the seller to pay and somebody else isn't. What do you think the seller is going to say about that? So the majority of the agents, it's part of your marketing, part of your expenses, if you choose to go that route. Time versus money, y'all. That's what it comes down to, time versus money. Hold your place in the book. And I want you guys to come back to page 805. If you're in a new book, what you're looking for is Appendix C. So 805, if you're with same book as me, if you're not, in the back, near the back, you're getting Appendix C. And what we have is an Appendix C is the residential square footage guidelines. Let's go ahead and call this your measuring Bible. Once you affiliate with a firm, you might even get they got a brochure that they can hand you and you can take with you. But this is straight from the commission. This walks us through the measuring guidelines. For your exams, what I want you guys to focus on is pages 806 and 807. If you're not with me on page numbers, it's the one that talks about the living area criteria. And then across from it, it's talking about attics, basements, bay windows, bonus rooms, etc. So 806 and 807, there's our above grade and below grade. There's our living area criteria, the 3 things that we must have. And then it gets into specifics, stairs, bay windows, etc. So what you need to know for your tests are there. If we keep flipping, we'll see some more that we'll see in post licensing. Yes, ma'am, Rosalind.
Hey, real quick. So you said it's important for 806, okay, maybe hold on.
Somebody says 750 in the old book. Thank you.
Okay, you said 806, 807,
Mm-hmm.
and 808, right? Or no, just
Nope,
807.
Just 806 and 807.
Are we finishing the helpful hints?
I'm sorry.
So at the bottom of 807, the helpful hints is not finished. It goes on to 808.
Yeah, I wouldn't worry about that. Yeah.
Okay, all right.
Thank you. Somebody said if you're an old book person, it's on 750. Thank you. But keep flipping through here and we could get like page 812. It gives you actual floor plans and different housing styles. So here's a 1-story with a basement and a carport with its floor plan and dimension. There's a 2-story with an open foyer and a finished attic, a 2-story with a bonus room, etc. So different floor plans, how those can look. Again, that's like after you're licensed kind of stuff. But again, if you want to flip through that now, just to kind of get a better understanding. Post-licensing, we spend a little bit more time measuring. But if you want to measure, if you decide to measure, the best thing you can do is just get out there and do it. You can read about it all day long, but until you get out there and actually do it, that's when it's going to hit home. So yep, 806, 807 are the first 2 pages. 750, 751. Living area criteria. And then just some of the some of the features there. Look that over. Questions? I got a little bit more to say about measuring, but let's go ahead and take a break. When we come back, we will talk more about this. Welcome back. We are still working with sellers. We've not listed this property yet, y'all. There's a lot of work that goes into getting it ready to list. We're close. So welcome back. Camera's back on. I'll take attendance. So just a few more things to say about measuring again, either between in your book where it's mentioned, in Unit 8, on pages 215, 216, and then those couple pages in Appendix C. That's all I want you guys to worry about for now, enough to get you started. Now let's talk specifically about measuring each room. This is not a requirement anywhere. Real Estate Commission doesn't require it. MLS doesn't require it. However, by putting in the room dimensions, it helps buyers determine the space. It helps them determine, is this room big enough for my furniture, my needs, whatever. So you may want to consider measuring each room and including that in your listing as well. And we're measuring each room. Remember back from Unit 4, we identified length times width equals square foot. So you have the length of the kitchen times the width of the kitchen, and that gives you the square foot, also known as the area of the kitchen, for example. Some sellers may require it. It may depend on the market. There's so many what ifs with that. Also, when we're talking about costs and measuring, also remember from Unit 4, we introduced you to something called the idea of cost per square foot. If you take the whole cost of the property, that word, in some cases, per is a fancy word for divide. So if we take the cost of the property, divide it by the number of square foot, that's going to tell us how much does each square foot cost. I think this comes more into play when we're dealing with new construction, when you're building from the ground up, because you got to count labor and supplies and overhead and all that stuff. But also in helping us cost, price this house versus another house, similar properties, same neighborhoods kind of thing, cost per square foot will give us an idea if they're running similar or not. So again, what we're looking at here is knowing how much each square foot costs. Do you guys still have your chats set to private? Bonus question. Tell me in a private chat, how many square feet are in 1 acre? Since we're refreshing Unit 4, let me just throw it in there. Some of you were ready for me. Again, this is dealing with land, not the property. I'm just throwing it in. Make sure we're all good. A little dyslexia there. So what we're looking for, is everybody in? What we're looking for, there are 43,560 square feet in an acre. 43 or 4 little old ladies going 35 and a 60. Is that how you guys are remembering it? That seems to be everybody's favorite. 4 little old ladies going 35 and a 60. Again, that's not for measuring a house or for rooms, but I threw it in there because we were refreshing on Unit 4. But it's good to know. A lot of those measurements we learned in Unit 4 can be, are we measuring the kitchen? Are we trying to find the cost of the kitchen by looking at cost per square foot? Or are we looking at the land, the property itself? So let's bring this home. When it comes to measuring, what do you guys need to know? Well, we need to know how to possess the information to accurately measure and calculate the square footage of most, hear me, residential buildings. Commercial are different. So it's just different. We don't have guidelines on those. There are no guidelines. If you're going into commercial, you need a good commercial agent to shadow. You need an experienced commercial agent that knows what's going on. But I believe most of us are going into residential. Like we said, if you don't want to measure it, you can hire somebody to do it for you. You just roll it into your cost of doing business. We talked last week about you guys being independent contractors. I did recommend you talk to an accountant, especially your first year, to making sure you're getting all your advantages, tax breaks and everything. So if you're going to measure, if you're going to hire somebody to do it for you, there's so many companies out there that do it. I would question them, make sure they know what they're doing, make sure they follow the residential square footage guidelines, because as far as licensees are concerned, that is the only way to measure. We all follow the same guidelines. Also, you guys remember, you can show me, how long do we keep our records? How long do we keep everything? People's hands popping up. We keep everything for 3 years, and that does include your measurements, your sketches, your graph paper, your calculations. Whether you measured it or somebody measured it for you, it shows that they did the work. So if you're measuring it yourself, it may look like chicken scratch, that you're the only one that can interpret it. But guess what? It shows that you did it. Obviously, if you're paying somebody, you'll probably get like professional floor plans or graphs, that kind of thing. Bottom line, we need to keep everything for 3 years. Commission roll, you don't need to know it. I just put it here for reference. We cannot rely on what the seller tells us their square footage is. They very rarely know. I can't rely on the builder's blueprints if it's already built. I can't rely on tax records. They're very rarely right. And we can't take somebody else's work from a previous MLS listing. Remember, if somebody else listed it before, that's their work. Do you know they did it right? Do you know they followed the residential square footage guidelines? If you take their work, not only are you copywriting, but you're running the risk of wrong information, and you're proving that you didn't measure it yourself. So yeah, there are these other avenues, and some of you might have been sitting there thinking, well, I just look at the tax records. No, we can't do that. Listing agents, it is on you. Either you measure it or you hire somebody to measure it for you. And that person should know what they're doing. I would hand them, again, once you affiliate with your firm, you'll get Appendix C and a brochure, more than likely. And I would hand that to them and say, y'all use this? And if they say, what is this? I would go on to the next company that says they measure for you. Selling agents, the ones working with buyers, for the most part, you can rely on MLS unless you walk in a room and your little red flag goes up or your buyer questions it. Guys, most of us don't have the spatial ability. Like let's say I advertise this room as 400 square feet, when in actuality it's 395. Most of us can't walk in here and be like, this isn't 400, this is 395. Most of us don't have that kind of spatial ability. That doesn't throw the red flag. What if it's 400 and I advertise 6? Most of us should be able to walk in this room and say, this doesn't feel like 600 square feet. This feels bigger than 600 square feet. So if your red flag goes up, or if your buyer questions it, then we have a duty to measure it. I have tape measure in my trunk. I have one of those laser pointer measurers. That's a fun toy. I mean tool. So you hold it up to the wall and you point the laser to that wall and you hit the button and it tells you how many feet and inches. And then you go do it again to this wall. Boop, how many feet and inches. You go. It takes me longer to go to my car to get than it does to actually measure this room. Everybody with me? But if
Wait,
it
how
comes,
accurate is it?
then I can verify that real quick. Yeah.
How accurate is it?
Oh, it's pretty accurate.
Okay.
I tested it. I tested it out. Mine is. I tested it out with a tape measure, right? I got accurate. And I think that's a good point, Tyrone. We want, don't cheap out, right? We want something, that works. And as soon as you get it, I would get your tape measurer and I'd make sure that it's that is accurate. You can use it for ceilings too. If you put it on the floor and do boop, it'll tell you how, how hot. It doesn't make that sound, but I wish it did. But it's fun. It's fun. I mean, it's work. It's a tool, but just things like that. There are devices and things for you guys to consider. I have a measuring video, and I'm not going to take the time in class to watch it because there's more in the video than what you need to know for your test. But what you do need to know for your test is also in the video. So I'm going to share the link with you guys before we leave tonight. It's a YouTube channel or YouTube video. The Winston-Salem Board of Realtors did it a couple years ago. And it just kind of shows, it's called the fundamentals of measuring. So it kind of shows you they're measuring outside, they go inside, they play with their laser measure, so it just kind of shows you some of the tools. It's hard to see it if you don't by looking at a book. So, hopefully the video can help solidify it for you. And again, if I forget, please help me remember. But I can share that in the chat with you before we leave tonight. And then you can watch that video if you so choose. Back in my admin days, I got you guys. I did new agent training a lot, and I got you guys right when you got out of real estate school. And I always gave you the homework assignment. Start with your own house. Measure your own house. It's a great place to start. You can't rely on the tax records, but you can use them to make sure you're close. If you had it listed with an agent, you can use it to make sure you're close. So I think that's a great place to start. Your own home. Questions on measuring. Let me make a note to give you guys that video because I will forget. Also, now that I have everybody back, I have a note here. Y'all remind me, if you're not back from break for the screenshot for attendance, please tell me in the chat. It's the only way I can count you here for this hour. If I can't see you when I go back and look at our screenshot for attendance, I got to be able to see you in the chat. When in doubt, just tell me you're here. Questions on measuring. Can we say almost 1,500 square feet? Bedroom close to 250 square feet. So unfortunately, the MLS just asked for specific numbers. Now, try at MLS. I put in a number and then it beep, boop, boop, and imports it, exports it as a range. So if you guys have ever seen listings for sale, a lot of times it might give you the range, like the heated square footage is somewhere between here and there. That gives you and I a little bit of wiggle room for error because we're not, professional appraisers or anything, but we do have that basic understanding. I would be very careful about words like almost and close because what does that tell the public? Probably not accurate, right? Proceed with caution, that kind of thing. But yes, try at MLS and Charlotte MLS report the square footage as a range, just to give us a little bit of wiggle room for accuracy. Anything else on measuring? Still working with sellers. We still have not listed this house yet. I got one more thing to discuss with the seller that we looked at in the listing agreement, but we didn't talk about how we got there. We somehow have to come up with a listing price. And in order to come up with the listing price, we're going to do what's known as a comparative market analysis, also known as a CMA. I'm not an appraiser. I'm not determining the appraisal amount, the value. What we are helping the seller determine with the CMA is probable sales price. Based on my CMA, based on my study of properties nearby that have recently sold, the theory behind the CMA is this is what a buyer across the street was willing to pay for this property. So we can use that to help us determine what a buyer might pay for yours. So we're looking for recently sold properties to help us determine the probable sales price. That's what we think a buyer would be willing to pay for it. Again, we're going to report in a range. Appraisers get to put in the actual number. You and I report in a range. We are going to get into CMAs when we get into Unit 17, our appraisers unit. One of the appraisers approach is awfully similar to our CMA, so we're going to talk more about that. We're not going to spend too much more time on it here. No, and I got a whole unit dedicated to it. And as we said a few minutes ago, when we were looking at our listing agreement, you can't put TBD in the listing agreement under the listing price. I cannot ask the seller to sign the listing agreement if we haven't determined on a listing price. Generally speaking, we want the listing price to be a little bit more than probable sales price to allow room for negotiations. Wiggle room for negotiations. How much more than probable sales price? That may depend on the market. May depend. But again, a lot more on this when we get to Unit 17. We've mentioned this before, our conflict of interest, the biggest conflict of interest. If you're listing a property that you are the owner, your name is on the deed, you can act as the seller and the listing agent. Of course you can. You cannot represent the buyer in that transaction. Old Car says I have my buyer's best interest in mind. But let's be honest, you guys, if my name's on the deed, whose best interest do I actually have? My own. Do we see the conflict of interest? All good rules got an exception. This one's no different. The exception to this rule is if you own and are listing commercial property and your ownership is less than a 25% interest. As long as you go into it with full disclosure with the buyer, as long as you tell the buyer, I have an 18.5% ownership interest, commercial property only, you can represent the buyer. I say proceed with caution. And then terminating of our listing agreements, we've already seen this back in Unit 7. We talked about terminating agency, so you guys already have this. Specifically with listing agreements, closing is what I'm working for. I get this thing to closing and the seller sells. I've done the job I was hired to do. We no longer have a listing agreement. If it expires, mutual agreement of the parties, if either party breaches, operation of law, if the judge takes the property due to eminent domain, that would terminate the listing agreement, destruction of the property, or death or incapacity of either party, remembering that the listing agreement is between the seller and the firm. So if the individual agent passes away, or if the individual agent's license goes inactive, the show goes on. In order for the firm to die, they would have to close their doors. Questions?
So if the husband dies and the wife is still wanting to sell, you would just do a new contract with just only the wife?
We wouldn't even have to do a new one. We could just edit.
Okay, okay.
And we would need a death certificate. So, I mean, closing might be delayed, right? Because we would have to prove to the attorney why that one party isn't there to sign off on that deed. I mean, not prove it, they would need it for their records. So depending on how long that takes. Something else when working with sellers. On page 217, we talk about the North Carolina Residential Property Disclosure Act. And the North Carolina Residential Property Disclosure Act gives us a couple forms. One of those forms is the Residential Property Owners Association Disclosure Statement, also known as the RPODS. Are you guys good if I call it RPODS going forward? Because if I try to say Residential Property Owners Association Disclosure Statement every time, I'm going to trip over it. And we're going to be here all night listening to me trying to get through that. So is everybody good? The RPODS is, one more time, the Residential Property Owners Association Disclosure Statement. This is a seller disclosure for residential property. If it's in an owner's association, it allows us to disclose that information as well. Now, some of you are sitting there scratching your head going, wait a minute, caveat emptor. The seller doesn't have to disclose much, do they? Well, this is where this form gets interesting. It's required of most sellers to complete, but they still have an optional disclosure. It's a mandatory form they have to provide to the buyers. But under caveat emptor, they have every right to say no representation. Mandatory form, optional disclosure. This is required on most residential properties. The biggest exception of the RPODS is going to be new construction or never before lived in dwelling. The whole point of this form is to disclose property information. And if nobody's lived there, nobody can really disclose anything about the property. So new construction is an exception. Foreclosures, if you're buying from the bank, that's usually exempt as well. For sale by owners are not exempt. So if you're that buyer's agent working with the FSBO, we have a duty to get this disclosure to the FSBO for them to complete on behalf of for our buyers. This is a seller disclosure. So who do you think completes this form? The sellers. You and I cannot do it for them. This is a seller disclosure. So they're responsible for completing it. We're going to look at it in just a second. We got one to look at. The RPODS needs to be kept accurate throughout the listing period. So if the seller does say, we'll see, we're going to ask them like 2.5 pages of questions about the property. Is this broke? Is this in good condition? Is this working all right? And the seller has 3 options. They can either say, yes, it's broke, no, it's not, or no representation. And if the seller says, yes, it's broke, and then it gets fixed, or if the seller says, no, it's not broke, and then it breaks, we need to update the RPODS. We need to keep this thing accurate throughout the listing appointment, the listing period. So if they do choose to disclose, again, entirely up to them, caveat emptor. If they do choose to disclose and something changes, then we need to get them to do a new one. Failure for the seller to provide this to the buyer. What happens if the seller doesn't do it? It could give the buyer a right to cancel. It could give them a right to terminate. I wouldn't get too bogged down on the specifics there. But if they do terminate for failure to receive the form, not because of how the seller completes it, mandatory form, optional disclosure. If the seller fails to provide it and the buyer exercises their right to cancel, they're going to get their deposits back. They're going to get their fees back. Terminate the contract. Both parties go about their lives as if this never happened. We will talk about those fees and deposits in Unit 10, I promise. If the buyer is already living there, Maybe it's a lease to own, for example. The seller wouldn't have to, I mean, the buyer tenant knows better about the property than the seller does anyway. But it gives them the right to cancel, the right to terminate the contract. The RPODS falls under Commission Rule 58A.0114. Again, don't need to know it, just have it there for reference. What I'd like to do now is go back to the online learning system, the Unit 8 material. And let's look at the RPODS, and we really needed a magnifying glass for this. But state of North Carolina, there it is, Residential Property and Owners Association Disclosure Statement. And it starts with instructions to property owners. It throws a general statute at them, tells them about what this form is about. And then it tells the sellers, you have to respond to each question, but you have the option of saying yes, something isn't working right, something isn't working as it should, in which case you need to explain your answer. The seller can say, no, I have no actual knowledge of the problem, or the seller can hide under the protection of caveat emptor and say, no representation. It doesn't matter how the seller completes this form. You and I always have a duty to discover and disclose material facts. So if the seller doesn't want to disclose, we must. Only the seller can hide behind caveat emptor. You and I have to follow license law and commission rules. So then we have a note to buyer, talks about their right to cancel if they don't receive it. Everybody signs it. And then starting on page 2, you can see we ask a whole bunch of questions. We're going to ask a whole bunch of questions to the seller. And the seller, for the most part, has 3 choices. They can say, yes, there's a problem. No, there's not. Or no representation. I think sometimes agents get excited when they see no representation. Sellers trying to hide something. Shady sellers. I don't know. Maybe they are, maybe they're not. Maybe they understand their rights that they don't have to disclose. Maybe they've had a tenant there for the last 14 years and they genuinely don't know. There could be many reasons why they choose no representation. It doesn't matter how the seller completes this form. If they go through and say, yes, there's a problem to everything, we're going to want them to get a home inspection. If they say no representation, we're going to encourage our buyers to get a home inspection. I tell you, the ones that make me nervous are the ones that say no for everything. No, there's no problems with this property. Nothing's broke whatsoever. There's no such thing. There is no such thing. If the seller fills out all no representation, can the buyer pull out of the offer? No. The only reason the buyer could terminate because of this is failure to receive it. Mandatory form, optional disclosure. They have the option to say no representation. We come down a little bit more. We go through 31 questions about the property. Then we say, if you answered yes to any of the above, please explain. Don't just say yes, it's broke. Be specific. You can attach additional sheets if necessary. And then the last page and a half are the owner's association piece. So if it's in an owner's association, if it's subject to an HOA, the seller's helping us out by providing that information as well. I really like this piece down here. What do those fees cover? That's what a lot of buyers want to know. What am I paying these HOA dues for? Well, if the seller's willing to share that, then we can fill that out in our RPODS. Seller disclosure. We can help, we can provide it, we can assist. I cannot put pen to paper. That's on the seller to complete the form. Mandatory form, meaning they have to provide it in most cases. Optional disclosure, meaning they have the right to say no representation. Questions on the RPOs? That's also in Unit 8. Another form under this act is the mineral and oil and gas disclosure statement, affectionately referred to as the MOG. Who remembers Unit 2? We talked about severing your subsurface rights. If the seller has severed their subsurface rights or they intend to sever their subsurface rights, then they have to disclose that to the buyer. Remember, we said a buyer has the right to know what they're buying. So if you're going to buy a property where you don't have those subsurface rights, the seller's going to disclose that. And again, we'll look at that form in just one second. But this is our MOG. This is required with new construction. The biggest reason the MOG would be exempt would be vacant land. Let's talk about that for a second. This one was one of the hardest things for me to wrap my brain around. You're disclosing whether or not you have severed the subsurface. Does that matter if you have a house on it or not? It's still the subsurface. So why in the world is this exempt from vacant land? I think honestly, it's a default in the way it was set up because this is under the North Carolina residential property. Vacant land is not residential property. I truly believe this was some kind of funny little oversight. I really do. Because that's its whole purpose, is to disclose things under the land. Shouldn't matter if there's a house on it or not. With that being said, vacant land is exempt from the MOG because there's not a residential property on it. Commission rule covers the MOG 58A.0119. Again, I just have it there for reference. Let's go back into the online learning system, Unit 8 material. And I have a MOG for you guys. So again, instruction to property owners, what their rights are, how they need to complete it. And then we got the representations. And I think the best way to see this form is to draw an imaginary line between 3 and 4. So the first part of this form, we're asking specifically about the mineral rights. Mineral rights were severed from the property by a previous owner. The seller can say yes, no, or no representation. Maybe they know their previous owner severed those rights. Maybe they don't. Seller has severed the mineral rights or seller intends to sever. If the seller has severed or the seller intends to sever, no representation is not an option. They either need to say yes or no. This is one thing that they need to disclose if they have or they intend to. And then we go through that same little exercise again, but with oil and gas. Oil and gas rights were severed by the previous owner. Yes, no, no rep. Seller has severed the oil and gas. Seller intends. Yes or no are their only options. Buyers have a right to know what they're buying. By the way, if you're ever an agent, listing agent, buyer's agent, and the seller has severed or they intend to sever, this is a attorney. Got to get the attorney involved because severing subsurface rights just got out of our realm really fast. So if they do say yes, we know we need to get one of their attorneys involved. Same right to cancel for failure to receive. Again, they can't cancel because they say no representation to the previous owner. Failure to cancel, I mean, the right to cancel for failure to receive, everybody signs it. Questions on the MOG? Seller disclosures.
So just to clarify, when these are supposed to be presented before the buyer makes an offer or it's presented?
Suzanne, before it makes an offer in practice, out in the wild, we see these things about 98% of the time are uploaded into MLS as an attachment. Only those that behind the scene member only thing can see. So for the most part, like I said, I'm just made that number up, but most of the time I have access to these before I ever show you property. So if there's a red flag that goes up, if the seller does disclose something, I had buyers once and they wanted to see a property and I pulled up the ARPOs and it said warning, black toxic mold, must wear masks. And this was before the day that we were wearing masks, you know. And I showed that to my buyers and they were like, yeah, no, we're good. And I was like, oh, thank God, because I might have had to sit on the front porch for that one. But I appreciate the sellers letting us know. I appreciate the sellers disclosing that. All you need is the right buyer that knows how to handle it. It's not a problem for them, right? But yeah, I'd say for the most part, we see these in MLS, but we do have to have it at the time we're presenting the offer. And that if not, that gives them that 3-day right to cancel.
So most listing agents, they have them go ahead and fill this out when they sign on. Okay.
Absolutely. Absolutely. Yep. There's no rule on delivery, just that they get it. So you're a buyer's agent going after a FSBO, right? And the FSBO may have it, they may not. And if they don't, as a buyer's agent, we need to get it to them and have them complete it so we can get it for our buyers. Everybody's got to assist in the delivery of this. And that's our job as brokers, is to make sure the seller gets it to the buyer. How that happens doesn't matter. Just making sure that it happens. Thank you. Other questions on our seller disclosures?
So Julian,
Yeah.
I suspect based on what you just shared, is there no way to discover severability as far as a formal document?
Not that no. I don't believe that. And I'm not,
Yeah.
I'm not going to sit here and swear to you, but I don't believe that is public record. I think that's, if it is, I've never found it, but honestly, you guys, where this form came from, this was an incident in Texas, and a buyer bought new construction. When the builder bought the land to develop it, the builder severed the oil rights, but they didn't disclose to the buyer. So then they started selling all these properties. Well, there was a buyer in his backyard one day digging around for something, and this is Texas, so he struck oil. And he said, oh, I'm rich. It's like Beverly Hillbillies kind of thing, right? And the builder said, yeah, no, that's mine. And a lawsuit came about. Now everybody statewide has a MOG to complete. But I tell you, coming soon to North Carolina, we're going to be dealing with fracking, which is extracting the gases, especially the closer east you get. So we might, we don't deal with it much here yet, but I have a feeling, and that might get a lot of our questions answered. I've never, ever seen yes. So I think right now we don't deal with it that much, but yeah, if this fracking thing takes off, we'll definitely be dealing with it. So let's bring this home. We always have a duty to discover and disclose material facts, regardless of how the seller completes these forms. Even if the seller says, no, nothing's broke or no representation, that's on them. Remember, we are following two different laws here. They get to follow caveat emptor. You and I get to follow license law and commission law. And as we said, all agents in the transaction need to facilitate getting this from the seller to the buyer. The majority of the time you can find it in the MLS. If you're getting ready to go show a property and it's not there, just call the listing agent. If you're getting ready to present an offer and you don't have it, you got to call the listing agent. We owe that to our buyers. Sometimes sellers drag their feet. Sometimes sellers are the ones that are delaying this. I can't make anybody do anything. I mean, what am I going to do? Put the pen in their hand and force it to the paper and say, you will fill out this form. All I can do is tell them failure to provide this could give an out for our buyer when we get one. And if the seller's ready to sell, they may not want to lose that buyer. But I can't make anybody do it. Regardless of how the seller completes this, the buyer should always be encouraged to have their own inspections and investigations done. We're getting into that when we get into Unit 10. Questions on sellers? We are done with sellers for now. For now. There's a lot to do with sellers. I think I mentioned this last week, but a lot of work goes into listing a property before you ever see it on Zillow, Realtor.com, whatever your favorite house for sale site is. There's a lot that goes into it. You haven't taken pictures yet, or a picture. Most MLSs require one picture, which means you at least got to sit in your car, take a picture. Please get out of your car, stand straight, put a little bit of effort into it. You may want to take your own pictures. You may want to hire somebody to do it for you. All decisions you guys need to make. Time versus money. Questions? We're a little bit early on break, I know, but let's go ahead and take a break. When we come back, we're going to switch gears and start working with buyers. So let's take 10. I guess this is our last break. Is that right? Is this our last break? Goodness, where's tonight gone? All right, let's take 10. We come back, we'll work with buyers. Welcome back. So I am going to take attendance. And let's put sellers off to the side for just a second. And let's work with some buyers. So you're working with buyers. You meet a buyer for the first time. It's one of the very, very first things you're going to want to do.
WWREA.
Early on, we need to do our WWREA. Thank you for whoever said that. I didn't see who that was. We're going to do our working with real estate agent disclosure. And thank you for letting me know that you're back for attendance as well. With buyers specifically, well, with both buyers and sellers, but specifically with buyers, once we do the disclosure, at that point, we got to determine in what capacity we're going to work. When I meet this buyer, I need to know right now, where am I going to put you on my plane? Are you going to be my client and get old car? Or am I going to be a seller sub-agent making you my customer, put you back in coach? What do the customers get? Honesty,
Material
fairness,
facts and fairness.
the disclosure, material facts. I love it. Y'all like, I don't know, something about material facts. Yes, honesty, fairness, and disclosure, material facts. Maybe they're willing to sign an agency agreement right now. Maybe they're not. Remember, we talked about the possibility of oral buyer agency. So we're determining on what capacity we're going to work. I need to know how to proceed. Do you get confidentiality? Do you get loyalty? Or do you just get honesty and fairness and disclosure material facts? Couple different options here. If the buyer's not going to hire you, the buyer's a customer. It's an unrepresented buyer. The buyer is a customer. You're working as a seller sub-agent. We've done our working with real estate agent disclosure. And remember, before I can show a property, I need to know that the seller and the listing firm will allow me to bring my buyer customer. So we talked about the MLS will tell you, buyer's agent, seller sub-agent, or both. If they say buyer's agent only, what they're saying is that brokers can only bring their buyer client. So if you don't have a client, if you have this buyer customer, you as a seller sub-agent are not welcome. They didn't agree to work with you in the listing agreement. They talk again about switching, moving that buyer from coach up to first class. So you started as a seller sub-agent. Now, somewhere along the line, the buyer says, well, I want to be represented. I want to be a client. Again, you guys, this is not the preferred method. This is not how we should be conducting our business. The Real Estate Commission doesn't want us to get in the habit of just acting like a seller sub-agent until it's time to make an offer. Too much could have already happened. This is like last ditch effort kind of thing. We need to go into this with some words of caution. When you're making that switch from hanging out with the seller to now being on the buyer's side, holding the buyer's hand, we need to disclose to the seller if we know anything about them. We need to remind them what we know and get their permission. Because once I make that switch, that buyer's now getting old car, which means I tell them everything I know about the seller. So let's be fair to the seller. Maybe you know how low they're willing to go. For example, once you make that switch, don't you have a duty to share that with your buyer client now? So we need the seller's permission to make that switch. Also, the buyer, this is good news, but yeah, we can only do that with informed consent. Again, this is like strongly discouraged. They just don't want us in the habit of conducting our business this way. They want us, I'm going to go back just for 1 second. We do the working with real estate agent disclosure. We do our job and talk about being a seller sub agent versus a buyer's agent. And then we decide from this moment how we're going to proceed. Not worry about switching people in the plane once we place them there. Does that make sense? So that takes us back to this commission rule. Once we do our working with real estate agent disclosure, we need to decide in what capacity we're going to work before we can begin. So to switch, why would you switch? Honestly, you guys, I think a big reason why buyers don't hire us, there's several reasons, but I think one of those reasons is we don't do a good job of explaining. We don't do a good job of delivering it. And if you don't sound like you know what you're talking about, why is somebody going to be eager to sign up with you? So if we're not doing a good job up front, they're more than likely to say customer, and then they get to know you and like you and decide you're good. And now you're making the switch. My point is we need to do a better job up front, making sure the consumer knows these are your options. We shouldn't have to make the switch. But I think a good buyer, I'll just be a customer. And then somewhere along the line, they're going to say, I kind of want representation. Can I get representation? Well, that takes me back to if we did a good job of explaining that up front, we wouldn't be here. So get good at your elevator speech, your spiel. So seller sub agent is one option we have to work with buyers. Buyer's the customer. We also have a non-exclusive buyer agency agreement. What's that word non-exclusive mean?
More than one.
More than one. We can put the buyer in a non-exclusive buyer agency agreement. I have a written non-exclusive buyer agency agreement. We're not obligating the buyer just to us. The buyer's dating several firms. Bottom line, the firm that gets paid is going to be the one that connects that buyer to the seller, the one that shows the buyer their home, their dream home. So you're only obligated to pay commission. The buyer is only obligated to pay commission to the firm that's the procuring cause. The procuring cause is which agent's actions led them to purchasing this home. Which one showed it to them? Which one introduced it to them? Which one took it? You know what I'm saying? Which one led them to them purchasing the home? If you can prove procuring cause, then you could be entitled to a commission. Non-exclusive buyer agency agreement. It's a written agreement. It's just not exclusive. We're freeing the buyer up to date as many firms as they want. We also had, we just talked about an oral buyer agency agreement. Now, before I flip the slide, who can remind me what duties do I owe a buyer in an oral buyer agency agreement?
All car.
That's it. Oral buyer agency. That word oral is just an adjective. Cover it up. What kind of agency are we dealing with? Buyer agency. Buyer agency says I owe them OLCAR. So if we're going to start under an oral buyer agency agreement, of course, we're doing our working with real estate agent. This is an express agreement, meaning the terms have been clearly stated. Implied is never allowed. Implied means I just start acting like your agent without any kind of conversation or discussion about it. Implied is never allowed. So this is an express, meaning the terms have been clearly stated. We can work with buyers and tenants under an oral agreement at first. Never sellers and landlords, owners, never for sale or for lease, only buyers and tenants. And we can work under this oral buyer agency agreement up until a certain point. And specifically that point is when we're ready to present the offer on their behalf. Hear me. There's a difference in writing an offer on behalf of somebody and presenting an offer on behalf of somebody. If you're writing an offer for somebody, you're filling in the blanks. You're asking them, what do you want to offer? What terms? When do you want to close? We're filling in the blanks of the offer, the purchase, and contract. That's writing an offer. We got to have our oral buyer agency agreement in writing before I present, before I contact the seller or the listing agent and say, hey, I have an offer for you guys. That's presenting. Does everybody hear the difference? We talked about how your test likes to trick you, not writing an offer, presenting. And that's the latest we have to put this thing, our oral buyer agency agreement, in writing. Also remember, an oral buyer agency, I cannot demand exclusivity. If I'm going to demand exclusivity, then we need to get it in writing.
Hey, Julie, can you go back to that last slide just for a second? Thank you.
Also, an oral buyer agency, it can't be for a specific period of time. If I'm going to look at this buyer and say, me and you for 2 weeks, 2 months, 2 days, if I put a time limit on our relationship, I've got to put it in writing. We've got to put this oral agreement in writing. So as long as you're not demanding exclusivity or you're not trying to create this for a specific period of time, the latest that we have to work is when we're presenting the offer. Once we get this thing in writing, maybe you do it from the onset, right after you do working with real estate agent disclosure. Maybe you're doing it shortly after you meet them. When you see that word exclusive, that means it's in writing. Exclusive buyer agency agreement means it's in writing. Again, some firms, some agents will not work with a buyer if they don't enter into an exclusive buyer agency agreement. Your test is not going to ask you guys what you're going to do. Your test is going to ask you what you can do. So we've entered into an exclusive buyer agency agreement. Exclusive meaning it's one firm, and guess what? That firm gets paid when the buyer buys. We have our musts, one of them being the definite end date. Exclusive means it's in writing. Okay, now for the fun stuff. You've met your buyer, you did your working with real estate agent disclosure, you decided how you're going to proceed. Are you going to proceed as a seller sub-agent? Are you going to proceed as a buyer's agent? And if so, are you going to proceed under an oral agreement or an exclusive agreement? Putting all that aside, now let's talk about what we get to do once we've created agency, what we get to do as a buyer's agent. I'm on page 242 or near the end of Unit 8. And you can see a whole laundry list there of things that we need to do. Once we establish agency or determine how we're going to work and what capacity we're going to work, probably one of the first things we need to do with buyers, agency's done. Anybody want to guess what we need to do now? Venture a guess?
Figure out what they want.
Yeah, I want to figure out what they want, but before I do that, I need to figure out
Compensation.
not compensation. I've already done that with agency. We've already
What
done
can they
that.
afford?
There we go.
Okay.
What you want versus what you can afford. Those are two different things in some cases, aren't they? So once we've established agency, I put you in my plane, that's done. Now I need to know how much house can you afford? And how we determine that is we get them to a lender. Again, you're going to have some preferred lenders that you work with. You'll get to know them. They come by and bring us donuts and, you know, all that good stuff all the time. If y'all like donuts, you're coming in the bread industry, I'll tell you that. So they'll come by and bring us donuts. You'll get to know lenders. You'll do a few transactions with lenders, and it's kind of like closing attorneys. There's nothing like having a lender on speed dial, right? So form those relationships. You're forming your village. It takes a village, and that's your village. Never look at a buyer and say, this is the lender you're going to use. I'm telling you right now, all lenders are different. They all come with a different product, different terms. There is no one size fits all lender. So what we want to do is encourage them to talk to 2 or 3 lenders, have something that they can compare and contrast these terms versus those terms. Y'all, I'm not the one buying this house. I'm not the one taking on a 30-year mortgage. That's them. So I want them to shop around. I want them to be educated about their loan. Before you show them property, y'all save yourselves and them the time and find out what they're pre-approved or pre-qualified for. We'll talk about those differences when we get to 14 and 15. Could you imagine spending months with a buyer, looking at what they want, and then come to find out they couldn't afford it? Could you, that's 2 months out of your life, your gas, wear and tear on your car, just poof, gone. So get them to a lender early so we know what we're working with. There's a common misconception out there that what I pay for rent will equate to my mortgage payment allowed by the lender. Rent and mortgage payment are 2 totally different things. So don't let the buyers talk you into that. Get them to a lender so we know what to show them. Now that we know what they can afford, now we can start asking them what they want. What are your wants? What are your needs? You know, talk to all the people buying. I know it's been my experience. I talked to a couple and I find myself wondering how I'm going to get both of them under the same roof, because he wants one thing and she needs something else. And I'm like, does this house really exist? Well, let's see. Let's go out and find it. Once we have their wants and needs, you guys need to be prepared for that wants and needs list to change. As they get out and start looking at properties, they get out seeing things. Maybe you can help them think outside the box. You know, I heard a trainer once, we were at a seminar, and I heard a trainer once say, don't ask buyers input questions. Don't ask them how many bedrooms they want. Ask them what they're going to do with that space. Maybe they don't need 4 bedrooms. Maybe they need 3 bedrooms and an office. You know what I'm saying? So don't ask them input questions. Ask them, what do you need the space for? What do you need these spaces for? Because then we can help them think outside the box and look at all properties that may or may not match their criteria. We also need to schedule showings. Never just show up at somebody's house with a buyer expecting to walk in the front door. With our listing services comes a centralized showing program. You can log on to the showing program and request showings. If you're doing multiple at a time, you can schedule, you know, different times. There's programs in MLS that allow you to determine driving directions between each property. So you can schedule, you can coordinate. Very helpful. If you're going to be out all day with buyers, if you're going to go out Saturday and show buyers 13 properties, you need to take into account potty breaks. We got to eat lunch at some point, right? I mean, it's a day. We're spending time together. So you need to be familiar. We need to be familiar so we can allow adequate time to get from property to property and anything else in between. So we need to schedule the showings. We always need to be in compliance with fair housing, not just when we're talking with our buyer clients, but with any consumer that we're talking to. Again, more on that. And did I do that? I did. Sorry about that. More on that in Unit 19. If the property's in an HOA, we want to help them get their hands on the covenants, bylaws, help them do the research. You know, all that stuff we did for the seller and the listing agent, we're kind of doing it for the buyer on interested properties, one that they're thinking about writing. If they're not interested, then don't do that research. But when they say, ooh, I like this, what do you think we should do? That's your cue to help them learn. Guys, remember, caveat emptor says, let the buyer beware. Caveat emptor says it's the responsibility of the buyer to learn about the property. When the buyer hires an agent, we take on that responsibility with them. So helping them look in those places where they can get that information. Discover and disclose material facts, always. Doing a CMA for the buyer. I know we talked briefly about doing a comparative market analysis for the seller, but we should do one for the buyer too. Because once the buyer finds the one, the very next question out of their mouth is going to be, how much should I offer? We don't just want to blurt a number out. Don't just, I'll just offer asking price. I'm sure it's fine. No, we want to do a little bit of research. We want to give them an educated response. So we're going to do a CMA. We're going to help them find probable sales price so they can determine from there what they want to offer. Helping them obtain, there's our seller disclosures, RPOs and MOG. Helping them prepare, present, and negotiate the offer. So once they do find the one, we're presenting it on their behalf. That's what it means to be their agent. I'm allowed to present it on their behalf. When a counter offer comes back, how are we going to help them negotiate? The seller generally starts up here, the buyer's down here. Hopefully every counter gets us a little closer and a little closer until we can meet somewhere in the middle. More on offers, counter offers, that kind of thing is all coming in Unit 21. Once we get under contract, funnily enough, once we get under contract, that's when the real work starts. Up to this point, we've just been out looking at pretty houses. They're not all pretty, but we've just been out looking at houses with buyers. Once they find the one and our offer gets accepted, that's when the work starts, because we're going to help our buyer do their inspections and their investigations. We're going to help them order the home inspection and the pest inspection and the survey, whatever it is that they want to order to learn about the property. We will talk about the buyer's contract to closing process. We'll start on it in Unit 10. When we look at our contract, we'll have a little bit more in Unit 21. So all the things that the buyer should consider doing to help them learn about the property. Questions or comments about a buyer's agent just easing in? Also, as a buyer's agent, as we've talked about, you may get to work with a seller that's going for sale by owner, an unrepresented seller. As a buyer's agent, you may get to work with a seller that's gone with a limited listing service. You may be communicating in both of these cases directly with the seller. You may not be talking to an agent. Avoid your conflict of interest. When you pick the phone up and call this seller, remember who you represent. Remember who you're out there fighting for. It's not the seller. Just because you got to communicate with the seller doesn't mean you owe them anything. So in these situations, everything you do is because that's what's in the best interest of your buyer client, helping them get through the transaction. And guys, remember, I'm not going to avoid showing a property to a buyer because they're not offering to pay me what I think I should get paid. We're going to look at our list, our buyer's agency agreement next, and we're going to see that it says that I will always ask the seller to pay me first. But if they can't or won't, you're up, buyer. Guys, there's only two parties to the transaction. Yes? There's only two ways I can get paid. So if the seller's not going to do it, buyer's agency agreement says that our buyer must. And this is a benefit, of course, of having that exclusive buyer agency agreement. Questions? So what we're going to do now, we're going to look at our exclusive buyer agency agreement. Again, most of the provisions are the same. There are some differences. Pages 243, 244, it's at the end of Unit 8. Goes over the provisions that are different from the listing agreement. And we're going to see some similar provisions, but the book kind of helps us on things that are a little bit different. And again, in the buyer agency agreement, if we look at the online learning system, I've highlighted what's in the syllabus. So this is what we need to focus on for now. You are encouraged to read the whole thing eventually, but right now, I'm just focusing on the highlighted. So our exclusive buyer agency agreement. Again, I have guidelines to complete it. When in doubt, find out. This agreement is between the buyer and whom? The firm. The firm. So the buyer and the firm enter into this exclusive buyer agency agreement together. There you go. One thing we didn't see with sellers that we see with buyers is the type of property. Is it going to be residential? Is it going to be commercial? What's the general location? The general location can be a address, 123 Main Street. It could be the state of North Carolina. You could have it as little, as broad, or as big as you want. Just be careful if you put the state of North Carolina, that tells the buyer you're willing to show them a property anywhere in the state. Honestly, what I see the most is like the Triad, for example. So it covers, you know, Forsyth, Guilford, surrounding counties. Remember that hesitant buyer, you are under an oral buyer agency agreement, and now you're ready to present the offer, and they say, I still don't know if I want to sign this thing. That's okay. I can create an exclusive buyer agency agreement just for 123 Main Street. I have created agency just for that one property. So now I can present your offer on your behalf just for that one property. If it works out, I got you. I'm your agent. If it doesn't, we're still an oral buyer agency. We can continue. So that general location, that word general kind of says it all. Just make sure you don't go out of your area. The term of the agreement, again, we have to have a definite end date. So it's going to begin on the effective date. And then I got a couple options here. I have an option for buyers who intend to purchase a single property. We have buyers who may purchase more than one property. What if you had an investor call you a few weeks ago and say, I want to add 12 homes to my portfolio in 2024. Can you help me out? You're going, well, I would love to. Thank you so much for calling, right? Once they purchase a property, they want to purchase another one, another one, another one. So the type of buyer, and again, 11:59 p.m. on this date, very specific date. So a definite end date in our buyer agency agreement. These are employment contracts, so we got to talk about the compensation of the firm. We mentioned the other day, briefly, a retainer fee. Your firm may allow you to collect X amount up front. You cannot collect a retainer fee on an oral buyer agency agreement, written only. But if you're allowed to collect X amount up front, it may or may not be credited to compensation. So if they don't buy, you've at least gotten something for your time and wear and tear. Again, you guys, totally up to your firm's policy if you can collect a retainer fee. And then we have buyer agrees that firm's fee for services shall be in the amount of. And in this field, you're going to put what your firm, I should rephrase that, what your firm expects to collect when you successfully help this buyer buy. This is not the total commission. This is what you expect to collect. And it tells us very specifically, do not put NA or 0. Because if you put 0, assuming that the seller is going to pay you, and you put 0, and then lo and behold, your buyer goes after a FSBO, and the FSBO doesn't pay you, and you told the buyer that they were going to pay you 0, how much are you getting for that transaction? That's a big 0, isn't it? So you need a number in there, because what if they go after the FSBO that's not willing to pay you? What if MLS advertises is at 0.5%? You need to put the amount in there that your firm expects to collect. Maybe you're getting it from the buyer, maybe you're not. Buyer agrees that firm's fees for services shall be in the amount of. We didn't say who was paying it. Then we go on to say that the firm shall seek the fee from the listing firm or from the seller. I'm always going to ask the seller or the listing firm to pay me first. If they won't, buyer and firm agree that the buyer will pay the compensation. This is how we protect our commission. This is how we protect ourselves if that buyer goes after the FSBO or they're only offering me 0.5%. I'm telling the buyer, I'm always going to ask the seller or the listing firm to pay me first. But if they can't or won't, you're up. There's only 2 parties to this transaction. I only got 2 ways to get paid. Again, as we saw with sellers, if there's any kind of additional compensation, a bonus or anything like that, I think we see this more often with buyers agents. Maybe the builder put on a bonus $500 for any all acceptable offers by the end of January, for some example. That would be additional compensation above and beyond what you expect to collect here. We have a duty to disclose that to our clients if we're going to make more than what we agreed. Questions on that compensation? Comments on that compensation? Most of the time, your commission comes from the listing firm through the MLS. But guys, I'm telling you right now, I'm not getting into detail about this, but there's a major lawsuit out there right now with the National Association of Realtors and the Department of Justice, the DOJ. Look it up. We're not talking about it in this class. But it's just a reminder, depending on the outcome of this lawsuit, it could depend on who we get paid from. And it just serves as a good reminder that we need these well-written, well-executed agency agreements to always protect our commission. And it's also a good reminder that real estate is an ever-changing, ever-evolving industry. So how it is today with the listing firm paying me, that may not be how it is somewhere down the road. Again, I'm not getting into that lawsuit. You're welcome to go to Google after class. Just put in NAR DOJ. You'll learn everything you ever wanted to know about it. But we are one lawsuit away from the whole industry changing. And this is a great example of what we mean by that. Who knows what's to come? At least by then, we'll all be in it together, right? So we'll all know what's up. Questions on compensation? We also have a protection period, working with buyers. So again, if they buy within X amount of days, we may still be entitled to a commission, or the firm may still be entitled to a commission. Commission is due and payable at the distribution of proceeds from the sale. So again, I earn my commission when I connect the buyer to their acceptable, suitable property. We don't actually get paid until it closes. If for some reason it doesn't close, it's going to be up to the firm if they want to go after the buyer. The firm's duties, what does the firm owe the buyer?
Check the door.
Yeah.
Quarter.
Is that right, Sal? Is that an accidental unmute?
I'm sorry.
You're okay. So make sure I didn't miss anything. Firm's duties to the buyer. In general, we're going to perform the terms of these agreement. We're going to seek a property at a price and term acceptable to the buyer. We're going to present your offer in a timely manner. We're going to disclose to the buyer all material facts related to the property. I owe you confidentiality, reasonable standard of care, representation of others. Guys, remember when we talk about exclusivity, that's a one-way street. The buyer is exclusive to the firm. The seller is exclusive to the firm. The firm is dating many buyers and sellers. Think about it. Let's see, there are 48 of us. I'm the BIC. So there's 47 of you. None of us would make money if we could only have one listing and one buyer at a time. In a firm this size, most of you are working with multiple buyers and sellers. That makes sense. So that exclusivity is a one-way street. It's only exclusive from them to us. But representing to the buyer that we may be working with other buyers, we may be working with other buyers that are interested in the same property. Shoot, one of you might be working with multiple buyers that are interested in the same property. Doesn't that sound like fun? What you need to do is make sure what you do for one, you do for all. Present everybody the same market data. Give everybody the same information. When we're working with buyers, it's risky to buy a house. There are risks involved. And one thing we need to help our buyers kind of pull out and determine is their risk tolerance. If you don't get this house, how much are you willing to lose? That's a hard question, right? That's a tough question. But based on their risk tolerance might tell us how much they're willing to offer. I'm not telling you what to offer. You're telling me based on my market data. So as long as I'm working with both those buyers on the same property fairly and giving them the same information. Submission of information to the listing service. So if your buyer buys something that's not in the MLS, the for sale by owner is not in the MLS. Once it closes, we're going to put it in MLS for comp purposes only. The public's not going to see it. It's not going to be for sale, but we're going to have it so we can pull it for our comps to do our CMAs. The appraisers will look at that as well. So if we're buying something that's not already there, then we may put that in. There's our non-discrimination clause again. Buyer's duties to the firm. They're going to work exclusively with the firm during the term of this agreement. They're going to immediately refer information about any property that the buyer may have interest in. They're going to comply with reasonable requests to supply information to get us to closing. Being available for reasonable periods of time to examine property. Buyers have different schedules. Not all buyers work Monday through Friday, 9 to 5. If they are working Monday through Friday, 9 to 5, when are you out showing their properties? Well, evenings, weekends, right? Whenever we can get out, whenever it's available. I've worked with 2 buyers now. I don't know how I've done this, but I've worked with 2 buyers now that work third shift. So we're either looking at property at like 8 o'clock in the morning or like at 4 or 5 o'clock at night, right? Because they're sleeping during the day. So helping to work around their schedule, being flexible if possible, being available for reasonable periods. Examining properties only by appointments made through the firm. There have been cases of buyers, especially when we go under contract. Cases of buyers just showing up at the property. They need to know it's not their home yet. And if they go on the property unannounced, some people would consider that trespassing. So have this conversation. You're not going to go without me. Even when we get under contract, they need to understand they can't go without me. Y'all, there was a case a couple years ago. We were under not we, but they were under contract. Sellers were chilling out in their living room one night watching TV, and all of a sudden they saw buyer looking through the window of the living room. Not cool. Not cool. So have these conversations with your buyers. It's worth it. Conducting all negotiations and communications through the firm. I am your liaison. I speak on your behalf. You just shouldn't have to talk to anybody. That's what you got me for. Conducting all due diligence on the property and then paying for all surveys, tests, inspections, reports, etc. We saw other professional advice in the sellers, but honestly, it's a bigger deal with buyers because now we're in the contract and the buyer's looking at you going, who do I use for a closing attorney? Who do I use for a home inspector, a pest inspector, a surveyor? I can recommend other services. I can recommend these other professionals. Again, you'll build your village. In the meantime, your firm probably has a village. They have their preferred vendor list that you can use. But again, I can't stress that enough. Don't look at a buyer and say, this is the home inspector you're going to use. Let's give them options. Let's give them choices. Don't send them to Google either. I mean, they could do that on their own. They don't need you. Confidentiality of offers. Commission rule we haven't discussed yet. I cannot disclose the terms of an offer without that person's consent. The person making the offer, I cannot disclose the terms of an offer. This crazy seller's market we are coming out of. Listing agents got themselves in trouble on the regular because they got multiple offers in their hand, and a buyer's agent calls and says, what's the highest priced offer you have in your hand right now? Commission rule says the listing agent can't answer that without permission of that person that gave the highest offer. There's no rule that says you can't call and ask. The rule addresses how you respond. So listing agents, when you multiple offers and you get that call, your response is, your buyers need to bring me their highest and best offer and see what happens. I cannot disclose those terms of an offer without their permission. And think about it. Is anybody in their right mind going to give you permission to disclose the terms of their offer? Give somebody else a chance to beat it? No. So we're going to keep those terms. Same thing. You're one agent working with two different buyers on the same property. We're not going to pit them together. We're not going to say the Joneses are offering this and this is what the Smiths are willing to do. We're not going to pit them together. We're going to keep that information confidential. Buyer's agency agreement, page 4, talks about dual agency as it relates to the buyer. I think you guys should read this. There's another explanation of dual agency, specifically working with buyers. So there's that disclosure of information, the firm's role as a dual agent, the buyer's role as a dual agent. And then like we saw in the listing agreement, we either agree to do dual agency or the buyer wants exclusive representation, and we are not going to do dual agency. Pages 4 and 5, your buyer agency agreement. There's another place for dual agency compensation. Some firms charge differently if it's an in-house transaction. So if your firm charges differently, if they have something different, this would be your opportunity to put that in. Termination, breach, mediation, attorney's fee. Any good contract is going to have what happens if it goes wrong. Surveillance, reminding the buyer that the seller shouldn't have audio. But like I said earlier, I do give my buyers the heads up because I don't want them to spill their beans. Photographs and videos, unless told otherwise, buyers are allowed to take pictures or videos of the property, not the stuff, but of the property for their record keeping. Remember we said you're going to take those buyers out this weekend and show them 13 properties on Saturday? I'm telling you, after a while, those 13 homes are going to run together. And what your buyers are going to do is start piecemealing. I like the kitchen in this house and the bedroom on that house and the dining room in this house. And they start building their own home based on the 13 homes you saw. So encouraging them to take notes, take pictures, to keep those homes separated. Again, They can do though that things that are in plain view. We're not zooming in on the contents of the desk drawer, right? Whatever's in the desk. But things that are in plain view, they're taking pictures of the space, not the stuff. And they're welcome to do that as long as the seller has said otherwise. If the seller doesn't allow it, then we need to honor that. They will let you know. You may have a situation, maybe you're supposed to meet the couple after work to show them a property, and one of them gets hung up at work and can't leave. So now you're with the other and you want them to take pictures. So when they do see their spouse later that night or their significant other later that night, they can, if it's worthy, they can share it with them and determine if it's worth the significant other coming and seeing the property another time. So that may be another reason why we want to take pictures. There's our wire fraud warning. Again, if your buyer wants to bring their money to the attorney, whatever they owe for closing, via wire transfer, we just need to look them in the eyeball and say, I will never email you those wire instructions. You need to pick up the phone and call the closing attorney. Got a place for 2 buyers to sign if the buyer's an entity or a business. And then we'll sign it, put the firm's information, we'll sign it on behalf of the firm. Because we're the ones signing it, we need our individual license number. Only 7 pages on the buyer agency agreement versus 13 for the listing agreement, but we have a lot more questions to ask the seller than we do the buyer. Yes, thank you. Questions on our buyer agency agreement? The last thing here, again, still working with buyers. We got to talk about dual agency. When you first meet a buyer and you're going over agency and what that means, you may want to mention dual agency, bring it up in conversation, but we don't really necessarily need to have the hard talk until and if your buyer becomes interested in something your firm has listed. So we can discuss it, the possibilities, the what if, but we don't necessarily need to have the in-depth conversation, get that informed written consent until we're either creating written agency or they're ready to go see something that your firm has listed. I don't want to scare buyers off. Buyers can be like these scared little timid creatures that run away easy. And if you're meeting them and you're launching into no advocacy and dual agency, it might scare them off. So, we need to bring it up, but we don't need to have the hard conversation until we're either putting that in writing or they want to see something listed by the firm. I think we can all agree the conflict of interest that comes with dual agency, the firm having to take a few steps back, not being able to advocate. Unintentional, undisclosed dual agency is never allowed. Dual agency is intentionally created with informed written consent of both parties. Questions? So when we come together on Thursday, we are ready to start commission math. This is the fun math. Y'all want to know how much you're going to get paid? This is the math we're going to do at the end of Unit 8. So bring your calculators. We're going to start with some math on Thursday. Specifically at the end of Unit 8, with the math concepts, you guys are seeing the commission map. I'm on page 245 in my book. So we're going to talk about that commission map and how we can determine what the listing firm gets, what the selling firm gets, and then how we take that a step further and what the agent's going to get. The other math in Unit 8 is seller net. So helping the seller figure out by the time you pay all your fees, all those expenses, what is left for you? What are we going to put in your pocket? I'm going to stop sharing just for 1 second. Don't go anywhere yet, please. And I'm going to grab that link for you guys with the measuring video. So again, I think Winston-Salem Board of Realtors did a nice job with this, and it's a couple years old. Somebody wants to know about the midterm. We're still a couple units away from the midterm. So on Thursday, we'll get through 8, we'll get 9, we might get started in 10. We're not doing the midterm until we're done with 10. So I'll know better where we are with that next week, and we'll talk about it when we're ready. It's been my experience. If I talk about it now, I'll have to talk about it again next week. And some things we can only afford to talk about once. So I got you covered on the midterm, and we'll talk about it when we get closer. Y'all pull your chats up. Ew, that copied weird. Oh, there it is. So it looks like you got a link. Did you guys get a link? Okay. All right. It looks funny on my end. But you should be able to click on it. Like I said, that'll take you to the Winston-Salem Board of Realtors. And they do a nice job. Again, there's more in the video than what you need to know. But what you do need to know can be found in the video. This is part of a series. So what I've sent you guys is episode 1, which is the big picture. There's also like episode 2, 3, 4, and 5. And those are specifically measuring. One's a ranch with a basement. The other one's a 2-story. I think there's one with a garage, something like that. So measuring specific different floor plans. You're welcome to look at that. You guys know how YouTube works, and it'll kind of pop up here on the right. So you can pull it and grab it from there. But I do encourage you guys, again, it kind of puts what we talked about with measuring. It gives you the visual. I know it's hard to see. Everybody get it? Anybody not get it? What else? Looks like we're getting out a few minutes early tonight. I'm doing that now because I know we got big math on Thursday. So if I can give you 5 minutes tonight, maybe you'll be more apt to do math on Thursday. After not, we got to do it. It came across as a picture. I know I got a link and a picture. Did you see the link though? Did you get the link? I don't know why it did that. There. You got it. Okay. So that's just the link this time. I don't know why it did that. But as long as you guys got it, and for some reason you don't get it, if it doesn't work, just shoot me an email. I'm happy to respond, or a text. I'm happy to respond. Any questions? All right, guys. 8, 9, get started on 10 on Thursday. Y'all have a good night. Y'all have a good night. We will see you guys on Thursday. I hear you.